Disappearing Burgers with Ronald McDonald and Friends.
Wow! Hamburglar has a magic kit.
Ooh.
Magic. Rubble, 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 cadabra.
I should have known you'd have something like that up your sleeve.
Rubble, rubble. All gone. All mine.
Oh, no, you don't.
Oops.
Now for a little trick
Rubble, rubble.
we can all enjoy.
It's a good time for the great taste of McDonald's.
What's shaking? Working out, Toucan. Sure could go for some fruit flavors. Fruit flavors? Just follow my nose. It always knows. Kellogg's Fruit Loops. Natural orange, lemon, and cherry flavors, plus vitamin C. Part of this complete breakfast. Delicious, but gotta run. Oh, no.
What's this?
A Garfield padlock. Whoa!
Wow.
To lock up your pad. There's one Garfield or Odie padlock free inside Fruit Loops.
It's Ken and new Jewel Secrets Barbie with 3 fabulous secrets.
We girls love lots of jewels to wear. Right, Barbie? Jewel Secrets, Barbie.
Jewel Secrets.
Step out of that gown for a night on the town.
Jewel Secrets.
Just right for a disco night.
Barbie has one more secret. Her ball gown is a purse. For you.
Jewel Secrets Barbie doll has 3 dazzling looks with matching play jewels. Ken dolls sold separately. New from Mattel.
I just love Cookie Crisp cereal.
Taking to disaster.
Not me. I'm on a roll. It tastes like little chocolate chip cookies.
And it's a crispy part of this complete breakfast. Well, Cookie Crisp.
I know. Another white cup.
If you like cookies, you'll love Cookie Crisp.
Cookie Crisp. This ball isn't normal.
The high bounce ball.
And now you can get one ball free in Cookie Crisp cereal. You can collect them in 5 dazzling colors. These high bounce balls are wow.
Constructs, you build. Thundering tracks, you build. Sky Blazer,
Sold separately.
action. Constructs. Rescue. Constructs.
Mission accomplished.
Constructs.
Constructs, Thundering Tracks, and Sky Blazer, each sold separately from Fisher Price.
Constructs.
Hi, I'm Ricky Schroeder, and I'll be right back with One to Grow On.
You know what happens to toys when the batteries conk out? Everything slows down.
It's
That's right. And your battery can conk out too if you don't charge up in the morning with a complete breakfast. Foods like fruit and cereal, juice, toast, and milk help give you the energy you need to do your best. So why not charge up with a good breakfast? It'll help keep you running all morning long.
This breakfast message brought to you by Kellogg.
Oh, no, Thomas.
I didn't do it. It was Katie.
Katie can't even reach the faucet, Thomas.
Oh, yeah, a burglar did it. He was trying to steal the towels, but Bugs and I scared him away.
Uh-huh.
He was wearing gloves, so I don't think there were any fingerprints or anything.
Thomas.
Everything was fine until this giant prehistoric monster stuck his head through the window. I guess he was thirsty.
Who are you kidding? Lying might get you off the hook once in a while. When you're caught lying, it's awful. And if you lie all the time, people won't pay attention to what you say anymore. So why not tell the truth and face the music? It's hardly ever as bad as you think.
By Peter Paul Cadbury, maker of Mounds, Almond Joy, York, and Cadbury's Dairy Milk Chocolate. And by Carefree Sugarless Gum, now with a new, fresher taste.
I may live through 2023. I'm not ready to go yet, okay? I'm not ready. You gotta wait. I got shit to do. I'm in the middle of something, all right? Just hold on. You are a cunt. Man or woman, you are a cunt. A C-U-N-T what? Cunts. I happen to love the word.
Watch your mouth. or don't come in here.
Uh-oh. Uh-oh.
Oh yeah, people, come on, we're adults here. You know what? What is the point?
Yeah, we're adults here. I got a fucking Burger King fucking thing on my head. We're all fucking adults here, guys. People in my chat, 2 words. What are they? 2 words. Let me see the chat flood. Let me see the chat flood. 2 words. Okay. Next caller. Please. Let's get into the meat and potatoes, which translate in American to dick and balls.
I got flip flops. These are my flip flops. Yeah, I really like my flip flops because I can put them on. Because look, watch me put them on. I can put them on all by myself. Watch me put them on. Look, are you watching? Look, these are my flip flops.
Thanksgiving Day. I remember it clearly. It was Thanksgiving Day. I was inserting myself in somebody else's fucking business as a cash grab, and you know.
This channel is harsh reality.
Karen Yak se jodió la sucia vida. Amen.
This is Jonathan Lee Riches. I have cheeseburgers. I'm gonna put cheese on them. I'm gonna make sure that I have my hamburgers because I'm a big boy now and I can make the hamburgers. My mom lets me use the stove now.
And I'm just like, wow, I like receipts, and they brought receipts. Like they had evidence to back up everything they said. And I'm like, okay, well, there's got to be another side to this, right? Like this can't, no, this is too fantastic.
Yeah, because you're not going to just jump to the conclusion that there's a conspiracy amongst cops to cover up a murder. You know what I mean?
Yeah, I mean, cops and just like soccer moms and shit. Like that's what made it even crazier. Like,
yeah, get it, Betty. Yeah,
did you have a close relationship with your mom?
Get it, Betty.
Oh, of course, I still do.
Yeah.
My older sister was kind of sad. She was more of the prissy girl that like going
that is
and
the
getting her
best
done.
shit fucking
Shopping for the dresses with mommy. I was the tomboy that liked playing with the people.
Shout out to Cherry for just being just easily the most faithful and loyal supporter that I've ever had. That someone could have that tenacity with loyalty. And I'm really blessed to have someone like Cherry be part of this channel and in my life. So it means a lot. And yes, I named him after Mr. T and Rocky. Say, woman. Say, woman. Say, woman. Said your old man ain't got no heart. Why don't you come down to my apartment tonight and I'll show you a real man. Oh my God, I'm so in love with this little dude. Yeah, I'm gonna go ahead and wrap this one up. I love you guys very, 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 very much. And we will do this again very soon, my friends. Oh, say bye. Say bye. Oh, I love you too. Give me a kiss. Oh, I love you. Bye, guys. Woo! Welcome, people. Welcome, welcome, welcome. Happy Friday. Hope everybody's doing all right. Hope everybody's having a wonderful start to their weekend. Today was a little weird. But overall, very, very, very good. Because there's a certain side of Twitter that was awful quiet. There was definitely a vibe. Oh my goodness. Let's see what nonsense this says. Hold on. But wait. No, God, church, don't do it.
I think we got a super dad. Super dad. I think we got a super dad. Super dad. Super dad. Super dad. I think we got a super dad. I think we got a super dad.
George Soros, U.S. Attorney Rollins exposed. I'm learning these a little bit, but first they didn't make any sense to me but this dude super chats me all the time, and I really appreciate it. But it's just like, I don't know what's going on. 911 Galera tell real truth on Soros weaponization of mass courts, cops, judges about John O'Keefe and Rick Kamal. Framed read and why got truthamerica.com. That is way over my head, my friend. That is way over my head, my friend. But I mean, okay. And the fact is I haven't heard anything about this other than your super chats, which I appreciate. Wendy, what's up, Wendy? It's good to see you. So I don't know. But when the stars align, then maybe that will find its way across my desk. Something else recently has found its way across my desk. I know Turtle Boy a while back did a blog on it, but it's really got me thinking. And I was DMing with someone else about this, and I'm going to be doing a lot about this coming soon. There's going to be a lot of I have a lot to say about this stuff. We got a lot of thinking to do on this thing. Ruby Chase, how did you guess? Yes, I will be talking about Sandra Birchmore because something really stinks there. And I'm shocked that this isn't being talked about all the time, because it stinks to high heaven. And again, you got to understand, I'm just catching up with you guys. I'm just catching up with you guys when it comes to what I believe to be obvious corruption going on. And if I ever doubted it, looking into Sandra Birchmore, I'm sure of it. I am so sure of it. The corruption going on in Norfolk County is disgusting. I'm blown away. Same players, different game. Absolutely. Very well put, Bookworm. Same players, different game. Insane. Absolutely insane. And guys, I have some special guests that are going to be joining me today. One not so short notice, one very short notice. One very short notice. And they are actually both backstage now. I had somebody else in mind, but they are unfortunately feeling under the weather. They could not make it today. That person who's actually feeling under the weather is actually Olivia S.A. You know what that means in this community, right? Just saying your name is okay. But I don't say that. I don't censor myself. So I'm going to go ahead. I'm going to bring on my panelists. I have no idea. We're going to try to go through. I'm going to be here a minute for sure. These guests are welcome to hang out as long as they want to. but we are going to go through the hearing today, and because man, I got questions, and one of my guests is somebody who I can count on to explain things, and then another one of my guests is somebody who I can guarantee I can count on to help explain things to my very uneducated ass. So let me go ahead and bring them both on. There is Sleuthy Goosey and my man from the Lawyer in the High Castle.
That's right.
Making Law Simple.
Well, yeah, you know what? So I should probably change that. I'm wondering which one.
What do I
your
call you,
guests
by the
I
way?
am. You can call me Dave. You can call me MLS. A lot of people
Okay.
call me MLS, but you can call me Dave or David or whatever.
Right
or the Lawyer in the High Castle. I'm cool with that too.
I'm just not going to call you Daddy, okay?
Yeah, don't
Like-
please. No. I got enough of that.
Sleuthy, your
okay.
sound is real bad. You got to fix that.
Either that or I thought maybe she had someone in the background talking.
Maybe that's possible.
Yeah, I think that's what that was. But
I did.
hey,
Is this
everybody.
better? Like, do I still sound terrible?
It sounds better, but you sound a little muffled.
Let me get off the headphones.
So, anyways, how are you? Oh, good. We can smoke on this channel. Oh, you're muted. What happened?
You can do anything you want on this channel. I don't give a
All
shit
right.
about
I
ad
got
revenue
the
at all.
Heineken. I got the
Yeah, right on.
It's Friday night, man. Come on, let's have some fun.
Yeah, I mean, I'm smoking my pen. That's about as crazy as I'm getting tonight. But I got coffee and I'm good.
So yeah, so I've been following your channel a little bit. I've chatted a little bit, and then I know you reached out to me and wanted to talk some Karen Reed and Turtle Boy. Yeah, today's hearing was actually, it wasn't as dramatic as I thought it was going to be. I'm really interested in the DNA stuff that they talked about. Was definitely interesting. I'm wondering why it is taking so long. That's always like the red flags that are going up. We're 2 months away from the trial, right? But that's not a lot of time, people. Like I have trials that are 4 months out, and I'm prepping for them now. I've got a trial next Friday, and I've been prepping for it forever. And now it's next Friday is like it's already here. There's no time. You need to do what you need to do well in advance. So 2 months is not a lot of time. Hey, Brandon, do you know Brandon Lesko?
I don't, but I assume you guys are friends.
Yeah. He's making he's in the LawTube community. He's not a streamer, but he's in everyone's chat, and he ties us all together. He's like a nice little ribbon. And
Right on.
yeah,
is he attorney? Is he an attorney as well?
No, I hope not.
Oh man. But thank you, Brandon. I appreciate it, man. That's a fake beer if I've ever seen one. Yeah,
That's right.
This dude is, yeah.
Absolutely. So
You've been
there's
exposed, my friend.
I don't have my mug. So there's a running joke with me. I don't drink a lot, and when I do, especially on stream, I tend to do things. My
Dos
chat
Equis?
calls it white girl wasted, and but I may have called the court a couple of times and things like that. But so that's my MO. But
Paul
for anyone
Christie-
who doesn't know me, I am a licensed practicing attorney in the state of Michigan, and my channel is Making Law Simple. And
which
I
is so I love that you have that name because you're going to need to simplify it for me. So I've been dying to get you up here because I have questions. Sometimes there's a couple of attorneys that watch the show and they'll be in chat and I am able to reference to them in chat sometimes. There's a creator named Lawyer Mystery Maven.
Okay.
Her name's Jess. And she's really helpful in my chat a lot and what I love too is like, because I'm very uneducated, and when I say something smart and I have an attorney validate me, makes me feel like, so.
Well, we're all here to learn together. That's the primary goal of my channel, and maybe poke fun at a few things at the same time. But yeah, that's what I try to do. I do it for my clients. I try to do it for the juries that I'm in front of, because the juries are like you. right? So
Right.
the more comfortable I can get explaining a legal topic to all of you, and you guys get it, the more competent I am, I feel, as an attorney in the courtroom.
Totally. I mean, when I approach cases and I talk about, real crime cases, and yes, on this channel we call it real crime, not true crime. When I approach real crime
It's a
cases,
good distinction.
Yeah, because if you notice, the true crime community is an absolute sewer and shit show now. So I really don't really want to be part of that. As I want to be as part of that as little as I can. It's just caused a lot of it's gross. But that's a whole nother conversation. But I usually will say things to the effect of I think of myself as if I'm a juror sitting in a jury box, paying attention to the evidence. So that's how I kind of approach things, because obviously the jury is made up of laymen, So,
well, if you're an attorney and you're a litigator, you should be approaching the cases that same way too, unless you're arguing a bench trial in front of a judge, or a motion to dismiss or something like that in front of a judge. You don't want to be super highly technical. You want to use layman terms. You want to appeal to them with the story. You want to convince them. A lot of times the jury needs a bad guy sometimes to hang their hat on, and it better not be your client if you're a defense attorney. So you got to create this. You got to create this story and convince them that there is some bad guy out there, but it's not my guy. And you gotta look at it from the jury's perspective.
Absolutely. Let me take care of the super chat real quick, and then I want to introduce Sleuthy. Paul Cristoforo, he basically helped, if not was responsible for organizing today's rally outside of the courthouse.
Oh, okay.
So thank you for the super chat. And he wants to say, before you start, I want to say thank you to my partners, Tracy and Dana, but more importantly, all the supporters that came out today in the cold. Love you all. We're going to show a little bit of that. Tom CPU is out there as always. And it was a great turnout. So we're going to take a look at that turnout a little bit. We're not going to spend too much time on Tom's video, but just to get that not a bird's eye view, but I mean, he's in there. So I want to be able to show that. And thank you again, Paul Cristoforo. And we appreciate everything that you've done. Absolutely. Sleuthy, what's up?
Not a whole lot. And I want to say
You sound fantastic now. Okay.
Oh, good. For some reason, if I am not on my headphones, which are supposed to be like noise canceling and stuff, it sounds better. So go figure. But
yeah, right.
Paul does. I see Paul just about everywhere. And I felt like, did you not feel like today was like, had the most people there than you've ever seen? It seemed like there were hundreds of people as opposed to like, say, 100 people. There was way more for sure than I even expected to be there. And
I was gonna ask if you had Tom's CPU up, because it looked like Thanksgiving like lined up for a parade. I'm in Detroit area, and that's what it looked like to me. Everyone lining up for it. Was a big party festival. It's like Christmas morning.
Right. And what's cool about that is, to me, that's kind of the vibe that you want at a protest. You know what I mean? Like when you talk about it, it doesn't really sound like the best thing in the world, is, because it's a very serious topic and the reason why people are protesting, but you want the vibe good, and you want it made up of rational, decent, cool people. Oh my goodness, George Soros, U.S. Attorney Rollins exposed. Thank you again, buddy. Let's see what this one says. 911 Glare, play first 12 minutes of your subs to hear that for themselves. 100% truth of what is really happening in grand jury, probably into Soros mass court chaos. Why they murdered John, framed Karen, and Canton 9 on YouTube channel Unsilent Majority 1222. Okay. I will do that.
Sounds like a riddle.
This person super chats me a lot, and I'm grateful, but I never really know what they're talking about. But he just gave me a YouTube channel. We will check that out later on. I just have to remember the channel. I'll go ahead and type it in. But as you can see, there is a hell of a turnout there from Tom's footage.
And I think one of the best parts about that is that, like, I did see people in the comments saying it's awfully quiet. There's not a lot of chanting. You know, they're used to the turtle basically screaming through that megaphone. But the thing is even if they weren't chanting nonstop, I feel like this sent a powerful message in the sense that they for sure thought since the turtle was in jail that nobody would show. Do you know what I mean? And it clearly didn't work.
Right. I think that that's an important thing to point out, because, oh no, let me leave that there. I think that's an important thing to point out because that's exactly what I thought. That's exactly what we suspect the effort of locking him up was. The entire purpose of it, at least as far as we suspect, is to, if you cut off the head of the snake, so to speak, as I've said many times, and them viewing Turtle Boy as the head of that snake, and the snake being all of these people, these minions, as they like to call them, you know, if they cut off the head of the snake, there's no leadership, and nobody's going to show up to this hearing. And they were obviously very wrong, and they were wrong about Turtle Boy. They were wrong about the people who respect and like Turtle Boy.
Government officials are wrong.
Go figure. Let's go, Brandon. Thank you so much. I can't believe Dave has been hiding beers on me. Far more disgusting than these charges.
He wasn't supposed to follow me here.
Nice. So yeah, I mean, I've said many times that I'm really, really grateful for this camaraderie I've built recently with this community, and they're mostly locals here. And
are you local? That's what I was going to ask.
I'm not. I'm in Tennessee. That's the whole crazy part of it.
Where in Tennessee?
Let's say outside of Knoxville.
Or you could say like East Tennessee,
the mountains.
West Tennessee.
Yeah. Yeah.
I got some buddies I stream with that are in East Tennessee. They always say East Tennessee is the best Tennessee.
There's too many weirdos.
Yeah, you could say I'm in
Tennessee isn't Texas. It's there are way too many weirdos to say exactly where you live.
So Courtney Sign says, my best friend told me today that Ken Mello represented her in a car accident lawsuit. This is interesting. He stole her settlement for $15,000. He did the same to someone else we know for $50,000 to $70,000. Alec Murdoch style, proven in court, he stole. Yeah, I'm not surprised after what we went over in regards to, and thank you, Courtney, in regards to some of the stuff that we uncovered as far as his practices go. Are you aware of that stuff, Dave?
I'm sorry, I missed that. I was distracted by the chat. I'll ignore the chat for a minute. Say that again.
So the super chat that I just got was somebody explaining that her best friend told her today that Ken Mello represented her in a car accident lawsuit, and that he stole her settlement for $15,000, and he did the same to someone else that they know for $50,000 to $70,000. So,
well, I mean, proven in court he stole. I doubt he would have a law license.
Well, that's the thing but he has been reprimanded twice. This is the first I'm hearing of accusations of him stealing the money. But
so the grievance, I mean, again, I'm familiar with the process in Michigan, right? So everything I say is based on Michigan with a general knowledge of the other states. But when you're an attorney, the worst thing that you can do is misuse client money. That's the worst thing. And if you are found to have done that, that is the fastest way to lose your license. Now, it might be a short suspension. The suspension could get placed on deferment at times. But if you do it like really bad or one too many times, you will forever lose your license. That is the quickest way to lose your license. So if it's that amount, I have to imagine he got severe license suspension, and why it wouldn't be a termination, I'm not sure. But, I don't know if all the facts are, I mean, it's a super chat, right? We don't have all the facts in the case. So
no, not in those particular cases, but actually I could send you a spreadsheet because couple
Doesn't have
days ago.
malpractice insurance. That sucks.
I could send you a spreadsheet that has some cases in regards to cases that he lost. Now, in all fairness, it doesn't list the cases that he won, you know. So, but the cases that he lost where he was the plaintiff just all stink of the same vibe of that super chat that we just saw. It's
well, I'll tell you
incredible.
this. I'll tell you this. All attorneys lose. If you have an attorney that says he's never lost a case, he's lying. Run for the hills. All attorneys lose a case because, you know, like Andrew Branca says regarding jury trials, there's always noise in the system. You can have a perfect case and still lose it because you're up in front of a jury. It could be, you know, a civil suit or whatever it is. You're up in front of a jury. I had a case that was a clear-cut personal injury case. I don't do them anymore. But we sent the jury to deliberate on the Friday evening, like it was Friday at like 3:50 or something like that p.m., the day before Easter Sunday. It was Good Friday. And we're like, okay, the jury's going to find the quickest way out. Check one box, no cause of action, return it, we're done. You know, and so there's just noise in the system.
Yeah. I now again, he was. Have you ever been reprimanded by the bar association?
I don't answer the question. No, actually, no. I do have one. No, I do have one.
I guess I
reprimand.
wouldn't expect you to tell me if you have, but
no, I do because actually some clients sometimes find it because it's public record.
Sure.
And so what I did when I first started off, I had you have to have an IOLTA account, which is a client trust account. You put all your client money in, and then you have like your general business account, bank account. Well, I was dumb enough and got the same. I ordered checks, right? They're identical checks, and I wrote my rent payment from my IOLTA accidentally, and it bounced because I had no clients. I had no money in there, so it bounced.
Wow.
And so the bar reprimanded me for that, but they didn't find that I abused client funds because there were no client funds in there. They just found that I misused my IOLTA account. So I've been through the process, and I've you know, every attorney gets grieved. So I've gone through the grievance process, but that was the only time I okay, yeah, my bad. I wrote a check from the wrong thing, but there was no money in there anyway, so it didn't matter. I had no clients.
I mean, but like, couldn't you have can't you you know, dispute that? I mean, it seems like a pretty simple explanation where you're just dude, I was writing checks and I wrote the wrong shit.
Yeah, but they said, well, because you wrote the check from the wrong account, that was misuse of your IOLTA account, even though you didn't misuse client funds.
So you're just not allowed to make mistakes like that.
I'm not allowed to make mistakes, apparently. And I was like, okay, whatever, fine. You know, slap me on the wrist and I'll do my thing. And that's the only time I've been reprimanded. It happens. But I've been grieved. I have clients that grieve me because they didn't like the outcome and thought I did something wrong. But
Sure.
those don't go anywhere.
Right. Now, if we looked you up, I'm curious about this. If we looked you up, would we be able to see reviews?
Oh, yeah, definitely. So I started this channel, my channel.
The reason why I ask, real quick, I'm sorry to interrupt you, but the reason why I ask is because Ken Mello's a ghost. Like, we can't find anything. No reviews, nothing.
Well, the bad reviews still get you up there in the Google rankings, so I'm fine with them. Most of my bad reviews, if you look me up on like Google, you know, Google Maps or whatever, are people that were never clients. Because at the beginning of April of 2020, I don't know if you guys know what was going on, but we sued the governor of the state of Michigan, and people came out of the woodwork trying to grieve me, give me negative reviews. I got hate mail that's still hanging on my refrigerator. I love it. So I got typewriter typed up letters with no signatures and no return address, and you know, and I'm like, oh, this one's going on.
Burn in hell.
Yeah, I know. I love the trolls. So yeah, you'll see stuff like that. But yeah, no, I mean, I'm out there, and if there's an attorney that you cannot find, usually they're retired attorneys or they're like corporate counsel or something. But if you have a litigator that you cannot find, something's up.
Nice. Yeah, he's a litigator. He does everything. He's done criminal law, civil law, plaintiff, defendant, whatever.
He's shady. He's shady. So,
he's
I mean, he might
so
get you a good
shady.
result, but something's shady.
He's so shady. Let me. True Crime with Eve wants to know: can Dave explain the why there is a protective order on 2 troopers' DNA, and what would make them not provide their DNA willingly?
Okay, so protective orders are things we use all the time. And I'm going to give you guys a real simple example of it. Say we have a personal injury case, right? Somebody's been injured and you sue. Well, the defense wants the plaintiff's medical records. Well, before you turn those over, you enter a protective order and say, listen, I'm going to give you these medical records and you can use them all you want in this trial, but they're going to be filed under seal, which means they're not part of the public record, and you can't share them with anybody. You can't, hand them out to your friends and say, oh, look at this guy, he got a whatever. You can't do that. It's to protect it. And then when the case is done and appeals are done, you must destroy them. You can't hang on to them. It's the same thing with like social security numbers. And so it's done quite a bit. In this particular case, the police don't want their DNA profile out so that it can be shared around and whatever, abused or used in some way. So they just want a protective order that says, listen, you can have it, you can use it for this case, you can admit it in evidence, but if anything's filed with it, it's under seal, so it's not a part of public record. And then when the case is done, you have to destroy that information. So that's all it is.
It's pretty normal, basically.
It's very normal. We do it every day in court.
Okay, so it's not shady in any way that they would put this protective order. It's just for the sake of protection. I mean,
yep. And we do it we do it with tax returns. If you're, in a divorce case or whatever, it's very much par for the course. It's just as much like a deposition or a discovery request. It's the exact same stuff. And most of the time, you don't even need to file a motion for it. Most of the time, other sides will just stipulate to it. In this hearing today, it sounded like the parties agreed, but they didn't realize they agreed. And there might not have been a need for this motion and hearing if they had realized that they were both talking about the same thing. So what the difference was is the prosecutor thought the defense was asking for the DNA samples, not the profiles. And the defense was just asking for the DNA profiles. So if they knew that they were talking about DNA profiles, and they both agreed to that, they wouldn't have had to have the motion. They would have just filed the stipulated protective order.
I'm glad you brought that up because Sleuthy put together this amazing spreadsheet in regards to the Karen Read case, which I just shared the link in chat. It's public. Anybody can reference it. I encourage everybody to reference it. Please, if you guys, those of you who are, with really large, big mouths and opinions who think they know everything about this case, yet you clearly haven't referenced anything, there it is. So please reference that before you start arguments with people on social media. And it's just full of very useful information. It's full of court documents. And recently, Sleuthy had updated it and put some stuff on there. Sleuthy, do you want to explain a little bit as to the most recent additions to that spreadsheet that you put?
I can, and I do want to clarify one thing, and then I would like to ask, a follow-up question. But so they weren't necessarily not willing to give their DNA. They just were kind of like, before we do so, we need to know that there is going to be this protective order, when you're going to get rid of it, how you're going to use it, who's going to take it, how it's going to be stored, and things like that. So they basically just wanted the particulars. They weren't necessarily saying that they didn't want to turn it over. But my question,
they knew that was going to be a losing argument. That's all I'm going to say.
Right. And so my question, so when you have a crime scene, you have people that show up at a crime scene. I've been under the impression that they take, everyone's fingerprints, DNA, that way they can be excluded in case there's some type of contamination somewhere in some part of the crime scene. So my question, I guess, would be, why wouldn't the Commonwealth already have that? Unless, I guess, he wasn't considered a crime scene wherever he was. Why don't they already have it on file to be able to compare it against?
Well, the defense doesn't have it. The
Commonwealth.
They said they did have it. They said they had the samples and the profiles, from what I remember of the hearing.
Well, because then the judge was like, asked that lady attorney that was there for them, was like, at any point in time, are they ready at like the drop of a hat to give these samples? And she was like, yeah. And she said, okay, so then just do the samples and then we'll figure everything else out.
Oh, maybe I was mistaken then. But why?
Yeah,
Okay, so what's your question then? Why wouldn't they have it?
Yeah.
Well, these are DNA profiles of police officers that were involved in the investigation. These aren't potential suspects. So why would they do that ahead of time? They wouldn't, because they're not suspects. I mean,
So
in their mind. All right.
I was
Right,
thinking
no,
the
well-
same thing. It was just like, because I think the motion for Jennifer McCabe's phone was denied too. Jennifer McCabe's and Nicole, or not Nicole Albert, Elizabeth Proctor's phone.
Hers was
were denied.
granted.
Hers was granted, but
So
okay.
the only one that was denied was Elizabeth Proctor, because she's not a witness. She's a witness for the purposes of the Turtles' charges because she's the wife of a witness. But for this particular instance, she's not a witness. But they are giving the defense Jennifer and Michael Proctor's communications from January 29th, 2022 to present. And then Michael Proctor's communications with Brian and Nicole Albert from January 29th, 2022 to like, I believe, February 18th, 2022. So the only thing that got denied was Elizabeth Proctor.
That
Okay,
part was denied. Okay.
but Jennifer McCabe's was granted.
Correct.
Oh well, that's. I mean, I'll take it.
Yeah.
I'll
I mean-
take it. So
Well, and they're still waiting on her records from the carrier as well. They haven't received those yet, but they were granted that. That's what they took to the Supreme Court.
Wow.
Okay.
Yeah.
I was
All
in
right.
and out. I was going
No,
to say,
go
I
ahead,
think
Dave.
there's someone in the background. I was in and out on this hearing this morning, so I tried to listen to as much as I could, but I was distracted at times, so maybe I missed that part where part of it was denied.
Well, the
Are you gonna-
problem
are
is everyone except for Yannetti and Jackson are boring. They're so boring. Like my attention just starts to like it's like a hummingbird. As soon as they start talking, I'm like, what are they saying?
And I think psychologically too that has an effect because we're just sick of the runaround that these people have been giving. So we're just automatically, as soon as one of these prosecutors open their mouths, psychologically, subconsciously, we're going to be like, oh my God, here they go again. But like I force myself to listen. The problem is I don't really understand a lot of what they're talking about. Nicholas Star Wars Trial Watch. Thank you.
Starov. It's pronounced the
Starov.
W just as a V.
Starovs. Thank you. The police union's lawyer filed a protection order, and they said they were ready to have the samples collected as long as the samples weren't handed over to the defense. Well, see, that's the thing is as I understand it, because last night I went over one of those court documents where that was filed by the defense, and it seemed like they were perfectly okay with, as long as they were like, you can put whatever protection on those profiles that you want. We won't leak them to anybody. They'll, nothing, as long as we just want the profiles. We just want to be able to test the DNA for the profiles against certain pieces of evidence.
Right.
And basically just saying and eliminating all possibilities of what it would be used for aside from that. It's all listed, very detailed. So, and yeah, no, I'm not putting the super chat song on when I got guests on here. Because I want to keep this moving. Right.
I'll do it.
I want to keep this moving along as much as possible. And Snack Devil is the abuser. Thank you for the super sticker. I appreciate that. Now I'm going to go ahead and play this. Either one of you guys, let me know to pause it whenever you want to chime in. And because I'm going to pause it when I have questions for sure. So let me go ahead and play this here.
the Commonwealth. Good morning.
Good morning, Mr. Larry.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Oh, you suck.
Good morning, Mr. Jackson.
Good morning, Your Honor. Attorney David Yannetti on behalf of Karen Reed.
Good morning, Mr. Yannetti.
Good morning, Your Honor. Elizabeth Little.
Good morning, Ms. Little. Good morning, Ms. Reed. All right.
Could I just have Mr. Reddington, could you identify yourself for the record?
Sure. Kevin Reddington, I represent Jennifer McCabe.
Good morning, Mr. Reddington. I appreciate you joining us today. I know that you're out of the country. Thank you. All right. So we have 4 sets of motions. The first one that I would like to address.
Okay, let me say something
was
real
that,
quick
Jim?
here in regards to this.
The
'Cause this
Zoom
has
pop
been-
ins.
Yeah, I want to go ahead and say, if whoever was responsible for that, fuck you. You're an asshole. That's absolutely my very solidified opinion of you, because I don't know if you noticed, but there was a lot of people out there on the front lines actually risking because make no mistake, those people out there that were picketing and protesting and supporting Karen Reed, what they were doing was actually risking their own arrest, because under the same laws that Turtle Boy is locked up currently, under the same law that the Canton 9 have been charged, every single person out there was subject to that. And they were doing everything they could to represent the people of Norfolk County and the Commonwealth of Massachusetts. They were doing everything they could to represent it well, and represent themselves and represent everyone who supports Karen Reed and all this and represents Turtle Boy. They were doing everything and putting themselves on the line to present an example of how to conduct themselves. And those people who did this on Zoom really pissed on that. So I'm going to go ahead and say fuck you for that.
Well, they're kind of potentially ruining it for others, right? So when the Zoom is open, most courts allow public to access it so that people can participate in the court hearing without actually being there. And they can't mute the entire thing because they have an attorney on there. And they can mute individual people, but you have to go, let's say there's 40, 50, 60 or whatever people in that Zoom room. You have to go through and mute each one of them individually. I don't know that there's a way to mute all and then just to unmute the one attorney. But then if someone else pops in, I don't, again, you're ruining kind of the whole thing that's making these trials possible. The fact that we can watch these things now. Sometimes I'm streaming cases off of WebEx, or sometimes I'm streaming it off of Zoom because we don't have cameras in the courtroom. And the more you guys mess with that and fuck it up, the less likely courts are going to be to broadcast these in the future.
Right. Which means you're also fucking it up for everybody who follows these cases and wants to watch these cases in real time.
Yeah.
Because they don't have to do that.
And I'll say this because I've heard this happen at basically every hearing. At every hearing, somebody's screaming something through the Zoom. And I feel like the worst possible thing that could happen here would be for them to exclude cameras from this courtroom. Like if your concern really is that there's like shady stuff going on, imagine if they didn't let you see or you couldn't see the files. So to ruin it like that, a lot more things you can get away with a lot more when not everyone's looking. And that's like asking for them to cut the cameras out.
Right. Because we're all here trying to convince the country and even parts of the world that those aren't just we're not just a bunch of mindless morons who are a mob, and we're able to conduct ourselves. That was embarrassing for everybody.
Yeah, I could tell you that Nick Staroff, who you pulled up, and then the Broken Bakers in the chat too. They're Swedish and Danish, respectfully, and they don't have public access to courtrooms. And I have a bunch of Canadians and Australians that follow me as well, and they don't have it. They love the fact that our courtrooms are open and broadcast like this, so that you can actually see what's going on, transparency, and all that disinfectant kind of argument. But don't ruin it for us, people.
Right. I mean, I like to see these things, you know? Yeah, so you guys suck for doing that.
When the fuck you Beverly came through, I thought for sure she was going to put an end to all of it.
Right.
I think it was somebody on Zoom.
Yeah, nobody can speak, so it only could have been maybe. I think we're all set.
All right.
Well, this is the other thing.
So the first motion I'd like to deal with is the defendant's motion for Rule 7.
Go ahead, Dave. Sorry.
I was sorry. I was just going to say the other thing too is the courts need to get up to speed on technology. Judges are so far behind in technology. The judge is like, I think that might have been on Zoom. No shit. It was it was on Zoom, lady. Sorry.
I've noticed. I've noticed the judges are always just kind of like, what do I do here? Somebody fix this. It's pretty funny.
17 records directed to Jennifer McCabe, Trooper Michael Proctor, and Elizabeth Proctor. Who's arguing that for the defense? All right, I'll hear you, Mr. Jackson.
Love this guy.
Free my boy Billy Tibbet. Free Billy in the trap.
Kevin, could you just be
Oh my God.
either mute or watch us?
Jim, that's not.
And you know, the fact that you did it over the defense trying to talk, you idiot. Like, if you're going to be an idiot, at least do it over the prosecution, bro.
Somebody else is saying, free my boy Billy Tibbetts. It's not me.
Yeah, McCabe's lawyer is like, dude.
Go ahead, Mr. Jackson.
Kevin, that was you.
Good morning, Your Honor, and thank you for giving us the time to address the court on these summonses for the third-party communications. I think I can cut this relatively short, given the Commonwealth's position that they are in agreement that the summonses for these third-party communications should issue. I want to save some court time.
Billy's innocent.
All right, so we may have to cancel Zoom for everybody if this
Man,
keeps up.
fuck Billy
We will
Tibbet.
have to cancel Zoom for
Shut
everybody
up.
if this
I don't know
keeps
who
up.
that is.
I don't either.
Fuck off, Beverly.
Oh, Brian is also an attorney. So thanks for
Go
being
ahead,
here,
Mr.
Brian.
Jackson.
Thank you, Your Honor. I want to try to save some court time and judicial resources. If the court is inclined, given the Commonwealth's position that they are in agreement with us to issue the summonses, I'll just submit on the papers and be done.
I have third parties that need to be heard.
If the court wishes, I'm happy to address the third-party concerns once they are heard.
No, I'll hear you now.
In terms of the papers that were filed, and my understanding is Mr. Reddington joined on Ms. McCabe's behalf with Elizabeth Proctor's motion and her position filed by her counsel.
I'm going to speed this up just a little
It
bit.
basically comes down to a singular issue, and that is one of privacy. They don't have standing to argue Lampron. They're not parties to this action. It appears the Commonwealth, who is the party to the action, has agreed that Lampron, the elements of Lampron,
Thank you,
have been met
Brandon.
with our
I
request
agree.
insofar as he is concerned, specifically and addressed to Michael Proctor, Trooper Michael Proctor, and his communications with Jennifer McCabe, Elizabeth Proctor's communications with Jennifer McCabe, Jennifer McCabe's communications, counter communications with
Thank you,
Elizabeth
George.
Proctor, and Michael Proctor's communications with Brian Albert and Nicole Albert. I'll address the issues that counsel raised in his moving papers on behalf of Elizabeth Proctor, because that's the only writing that I have to go on at this point. He basically argued that there are false statements made about Michael Proctor's relationship with some of these other parties. Since the very beginning, and that brings up the fundamental issue, Your Honor, of what is that relationship and what's the nature of the relationship, and why do we believe that that relationship establishes extrinsic evidence of bias and an inability to be neutral. From the very beginning of this case, we have questioned the neutrality and the bias of Michael Proctor and certain other government witnesses based on overwhelming facts that we've learned, overwhelming facts that established that both this...
I got to say that I love that this is like one of the first things they're bringing up, you know, and lest we forget, ironically, Turtle Boy is currently in jail right now for being the one who actually made everyone aware of this inappropriate or conflict of interest, the nature of this relationship between the Proctors and the McCabes.
Right.
It was his investigating that did this. And here it's helping the defense. And it's nothing, he did nothing actually wrong, in my opinion, anyway. He had a source that he used, and that source got outed, and that source got charged, and he got charged with conspiracy.
Well, he was
And
charged with conspiracy for the license plates and
well, that's what
that
this
they were
is.
they were at the house that Proctor was at, whatever their name's his house. There's so many freaking parties I can't keep track of them all.
Right, and that, and the picture, discovering that they were that Colin was a ring bearer at their wedding. They were sitting at the same table. He obtained these videos, and he obtained these photographs, and uncovered this through his investigations, and he's sitting in jail for exactly what they are bringing up right now in her defense. And this is not there's nothing unethical about that, because if that can exonerate a potentially innocent woman, then that's exactly the purpose that it served.
Yes.
I don't understand how they're still denying.
What do you mean?
Right. It's funny how they.
They're saying that,
Oh yeah.
Like, that's not her. What do you mean it's not her? Who is it then?
When we get it was
Still a year
not
later,
her
it's like it's not
kids,
her.
and
Yes, it is.
Yeah, it was like Jennifer's friend that knows this person, that's cousins with that person, this person. He was exaggerating it. No. Don't exaggerate it. Tell exactly what it is. They are friends. They were in a wedding together. Not only did they happen to show up at the same wedding, they were in the same wedding party. So classify it as it is.
Right.
Well, then he tried to say he was a young boy, like essentially. So you're suggesting that Michael Proctor's sister didn't know a single young boy to be a ring bearer but him? So they asked this stranger kid to be in their wedding? I find that very hard to believe. It's just, if you didn't know it was bad, why do you continue to deny it?
Yeah, it's really funny to me. They don't fully deny it now because the evidence is there. But prior to that, Michael Morrissey himself made a public statement saying this is absolutely untrue. They have no connection. They don't know each other.
They say it today. They say they're saying that the little girl in the picture is Jennifer McCabe's daughter, and it's not. But it is.
Right.
I always flip it. I always say, imagine they're on trial. They're the defendants, and they're trying to say that they don't know these other co-conspirators, and yet all these pictures pop up. You're like, so first you said you didn't know each other at all, and then these pictures pop up, and now you're changing your story to say, well, we did, but it wasn't really like we knew each other. And then there's like, oh, you're in the same wedding party. Oh, well, we did know each other, but it wasn't like we were working together. And it's like, okay, you're going to prison, right? You're going to be found guilty.
Yeah. Then finally, the most watered down possible excuse they could have is, it was over a decade ago.
Yeah, exactly.
Come on, Thomas.
Well,
Fleming,
and she didn't help because she
took
was
away
like,
anything wrong. Here's there for behavior. It goes for beyond. I agreed, Thomas. Thank you so much. Go ahead, Sleuthy. Sorry.
Then Auntie Bev, she says, and what year was that photo? Like, she was prepared to kind of brush that off because it was, say, a decade ago. And his argument was, you're acting like they had one encounter a decade ago, and I'm trying to show you that they've been friends at least a decade, kind of thing. And I do, once we get to it, I do want to talk about it, but he makes a really, really good point when he brings up exactly what Lally said at a previous hearing with regards to like what an actual conflict would look like between these people. And then you add in the information we know now.
Now, remember what this is. This is a discovery motion, right? They're trying to get at information. So they're not saying we absolutely know for sure that these people were friends together. Like, there's a guy I went to like kindergarten through middle school with, and I stood up in his wedding. But I haven't talked to him since then. It's been 20 years. Now, I wouldn't necessarily consider him my friend anymore, but there is a past. But if I say that, and then you start going through my Facebook posts and you start seeing a bunch of pictures of us together over the last 20 years, then you know I'm lying.
Right.
Yeah.
So they're not saying,
or you're like, he's just in the background.
Sure.
I wasn't really worried.
But there's enough here to let us get some discovery going, Judge.
That's what I don't understand. Like, here, the whole premise is you have to prove to us that you're going to find this and exactly specifically what it is that you're going to find and why you believe that. And it's like, well, how am I supposed to do that? Because I'm giving you like our theory, the evidence that we're using to back up our theory. Now we need the actual data so we can actually prove it or debunk it. And you're not letting us have the data. And that's what I thought was interesting about the DNA stuff at the end. It gets a little heated towards the end. It's subtle, but when they start talking about the DNA and Yanetti's like, to be quite honest, like, we shouldn't have to come to the court every single time we want to run something, that DNA, against our evidence. I had a big feeling that they have some kind of physical evidence that they were not trying to bring up in court. And wouldn't you agree that they don't necessarily, like, the defense doesn't have to let the Commonwealth know exactly where they're going. They don't have to turn over
They don't
every
have to
bit of
show them
evidence that they have.
Yeah, well, no, they do have to turn over evidence that they intend to introduce at trial, but they don't have to say why. You know, I can I can bury stuff in a bunch of stacks of documents, and nobody knows that the thing right in the middle is what I think is the linchpin to this case.
Right.
Right. And then boom, an ace card.
Coming back.
Yeah, but I have to
they
turn over.
want
I'm like,
her to
nope,
keep-
it's page 77 of the 140 documents I sent you.
Yeah, but they want the defense to keep coming back and like writing these enormous motions and making these oral arguments for why they need to do testing on something else. And it's like,
Well,
I
what's
don't feel
funny
like-
is, the state will never bend over on anything, but they will be the first to come into the defense and say, well, you want to just stipulate on these text messages, or you want to stipulate on, no, you didn't give me any breaks. I'm not giving you any breaks.
Yeah.
But yeah.
They make good points here. And then when everybody got up at the end, like the entire defense team was like jumping up to say something additional. And I felt like it was very much, okay, well, if this is going to continue to like get brushed off, then we're filing a motion for sanctions and to have him disqualified, and a motion to dismiss. And then,
Yeah,
Elizabeth
I
Little
saw
gets
that
up
at
and
the end. That was great.
Yeah, she's like, also, we haven't gotten the stuff that we were supposed to get, weeks ago from her cell phone data from the carrier either. When are we going to get that? And it just was very, I also want to know your opinion on the end when they were like, we have to do it on this date. And everyone's like, we're at trial this date. That's not going to, what about this date? She's like, no. Everyone's like, no, it's not going to work. It has to be that day.
Yeah.
Well, I mean, okay, so the judge controls the calendar, the docket calendar, right?
Right.
But you also have to take into consideration the attorney schedules. But at the end of the day, the judge has other cases. The judge has other trials. So do the attorneys, presumably.
Sure.
So
And
they're
she
trying to
wants-
make it work. It's just like, I'm not moving the March 12th or whatever it is trial date.
Right.
So, there's probably a court rule that says that you have to have evidentiary issues done and disclosed by a certain date. Like in Michigan, it's 14 days in advance of a trial. So she's like, if I'm going to hear an order or hear a motion on this and issue an order and give you guys time to exchange stuff, it has to be by this date.
So let me ask you, that date was today. So at the end, she says, today was the deadline for evidentiary motions.
Yes.
So at this point, after this, there can be no more motions to suppress, or can they still file motions to get, like, it sounded very
They
both
can-
sides of the mouth, like,
They can file
Go ahead.
show cause motions and contempt motions or motions for sanctions for violating court orders. The judge has already ordered stuff to be turned over, I think 3 times, and they still haven't gotten it. That's probably the motion for sanctions. And so they can still do all that. And then they can also, in the middle of trial, if like the state decides to try to introduce something that wasn't disclosed, they could bring they could sua sponte bring a motion and be like, no, judge, they have a duty to disclose it within the certain timeline before trial. They didn't, they can't use it. So, it's just like, it's the big picture evidentiary motions that are sort of time barred now.
Right.
Yeah.
And, a lot of us have been looking at this like, well, once this goes to trial and once that goes to trial, it's a no brainer. That's it. There's no jury that's going to convict based on this stuff. Right. Even I've been saying that. But the thing is, though, is we have to also
Well, I wouldn't say no jury.
But there's also, we have to keep in mind that this evidence has to get to a jury first. A judge has to approve what evidence is going to be entered, and the jury's actually going to get to see. So this judge could just throw a whole monkey wrench of whatever the hell the defense is trying to do. the prosecution as well. But we have to keep that in mind.
Yeah,
The
just because
evidence
they
that
get
we're
access,
aware of,
yeah, just
it
because
doesn't mean that the jury's going to see it.
exactly. So let's assume they get this evidence that they want, and they still then have to admit it at trial, and so the judge could deny it, or for various reasons, or maybe the evidence doesn't pan out to be what they actually think it might show. So there's a bunch of reasons why it might not get admitted, even though they have a right to ask for it and get it now. At least I'm the type of attorney that I want all the information. I want it all. You say that you guys have been together for 5 years. I want all of your text communications. I'm going to flip through them, and so a lot of it's not going to be relevant, but I want to know, and I want to go through it all. And so that's what they're doing. They're asking for all of it. I want every possible piece of information that I can use to defend.
So like I might have I don't know if so you're a defense attorney, I'm assuming. I think you did say that at some point.
I used to work in the prosecutor's office right out of law school, and then now I do criminal defense, civil litigation lawsuits and things like that, and family law.
Good. So then you're able to look at both sides, which I think is super important. Like I have to learn. Like I don't care about anything but knowing like all the information and learning more to kind of expect and be able to explain things and figure it out with this stuff, because even though it's always changing, it's like you really don't understand how much of your life you're basically putting in an attorney's hands when you go into court, because you don't know anything about the law. You don't know anything about procedure. You don't know anything about the law. And so I'd like to
for what you people charge too, man. Like
you should.
I expect you to.
Oh my God.
I expect you to think for me, dude. Like here's my money. Just get me out of this now.
Well, yeah. But see, that's the thing. It's funny. I always have conversations with my new clients, and I say, all right, I'm going to give you 3 things. I have a magic wand. And I can wave it around and give you anything you want. What's that? And then what is like the lowest you'd be willing to resolve this for, whatever it be? And then what's sort of our middle ground? And because we don't have magic wands, right? I always say attorneys are like parachutes, right? If you jump out of an airplane, we can't
still gonna hit the ground.
We can't put you back in. You're gonna hit the ground.
Right.
We're just the parachute that helps maybe soften the blow, right? So Karen Read, even if she's acquitted, her life is completely different. She's hundreds of thousands of dollars in debt or a cost or whatever. Her life is on hold. She's got stress, anxiety. Who knows what sort of mental health things she's going to have going forward. We're not going to prevent you from having all of that. We're just hopefully going to soften the landing a bit. So that's sort of a better analogy for attorneys.
Yeah, it's also way less definite than I thought it was. Like I thought, okay, so I do this happens. You do this and I respond this way, then this happens. And that's not it at all. And that's one of the things that frustrates me the most, I guess, is I could read documents from the Commonwealth, well, I shouldn't even say that because I hardly ever read through them. And I'm like, oh, that's a really good point. But in other cases, I'll read, let's say Brian Kohberger, I'll read one of the filings from the prosecution, one from the defense. I'm like, oh shit, they both sound good. Like they make good arguments on both sides. I wouldn't want to be the judge, but you don't know what's going to happen regardless of what you say, or,
well, you don't. And I
always happen.
And you're only responding so I just filed a lawsuit on behalf of one of my clients. And I said, okay, now the ball's in their court. And I don't know how they're going to respond. Are they going to, are they going to file a motion to dismiss? Then I got to deal with that. Are they going to file an answer at all? I don't know. If I send them over, discovery requests, are they going to just answer them and we're not going to have any issues? Or do I need to chase them down and do all this? And then on top of it, I might, like you said, you've read things. You're like, that's a really good argument. So I file a motion, say to dismiss, but the judge doesn't think it's a good argument. You always forget there's a judge involved. There's a minimum 5 different heads and personalities involved in any case. And that's both parties, both attorneys, and the judge. That's just at a minimum. There's usually a lot more. There's also the mediator, and there's facilitators and things like that. At least in civil suits, there's the mediators and facilitators. But, there's a lot of people involved. And behind the judge, even there's the judicial clerks. I used to be a judicial clerk, and when we would get motions, I would be the one reading them, researching the cases, making my notes, and telling the judge what I thought, and she would sometimes go with me and sometimes not. But the judicial clerks have a lot. Not the judicial clerk, the judicial attorneys have a lot of sway in the chambers as well. So there's a lot of people involved, and it's not at all clear cut. That's why they call it the practice of law, and it's
for sure. I
you would
I
hope
look at
it
it
would
from a
be.
perspective. I thought it was. I always did. I thought it was, and you could probably persuade me to get more into it until I realized it wasn't, and then I was like, no, I have no desire to, like, 5 years from now, a judge makes a ruling on something that's totally different than what it was 5 years ago, and now we're looking at a totally different argument to get something that we need. But I look at it. So Andrea Burkhart, she's an appellate lawyer, and she was
Yep.
like one of the first lawyers that I ever started speaking with. So I got very used to looking at court documents in kind of her perspective, which is critical of everybody. Like when appellate lawyers coming in, they're not just, your appellate issues are not always necessarily what the prosecution did wrong. It could be what the defense also did wrong. So I look at,
Yeah, it's very rare for the appellate attorney to be the trial attorney for that very reason alone, even if your best shot is to throw your trial attorney under the bus. So you don't want to be the trial attorney because doing the appellate work, because it might not be in your client's best interest. It might be throwing you under the bus, and that's fine. It is what it is. Take whatever avenue you can for the appeals. So yeah, there's just you don't want to go to the appeals anyways, especially not in this case. See, Olivia has a question for me. Is it normal for the defense to only have 2 months with the evidence and the state to have nearly 24 months with it before trial? No, it's not. Generally, I mean, again, I'm speaking from my Michigan perspective. The prosecutor should be turning over the evidence as soon as it's available, and to the defense. But there could be a situation where the evidence is newly discovered even by the prosecutor. In that case, the prosecutor wouldn't have it for 24 months. If it's denied, it's not turned over, then you file a motion to get it, and then they should turn it over. And again, it's not normal. That's why there's a motion for sanctions coming, because it's I haven't been following this case, every single hearing, but it's my understanding that there's been 2 motions granted regarding discoverable information on the same thing, and they haven't turned it over. And so that would be sanctionable.
And on top of that, well, this is, I guess, against the judge, not necessarily the Commonwealth, but they also had to go, she denied multiple times when they were looking for data from Jennifer McCabe's phone. And they brought those same arguments to the Supreme Court, and they overturned Judge Bev or Judge Canoni or whatever her name is. So it just seems like a constant struggle and battle for things that are, for example, the taillight. How would you not assume that that's one of the very first things that would need to be turned over, kind of thing? Massachusetts has really thrown me for a loop, because it seems I'm used to other states where you're asking for it, it's evidence that was collected, it's getting turned over. Do you know what I mean? It's not an argument.
Yeah.
You don't have to explain why you need it. Like, they're giving you everything, even the stuff that they're not going to eat. You know what I mean?
Yeah. So, and I see where where Olivia goes on with all that was discovered was supposed to be produced by August 12, 2022. With regard to the taillights, my understanding that the prosecutor, so he claims, didn't know that they were in possession of it, because it wasn't in sort of the normal evidentiary. They had no record of it being collected. It wasn't in the paperwork, and it was just sort of sitting on a shelf somewhere, and they didn't know that it existed. Is that my correct understanding of what the state has said anyways about that?
They did. They just kept putting it off as that the state lab is just very backed up. They don't have, and then come to find out, when the defense was looking at different evidence bags or photos of evidence bags, they figured out that Michael Proctor had gone and like collected pieces of taillight over 5 or 6 different undocumented searches. So it's hard to tell if those are included in there. But essentially, every time Lally would get up there, he just said, it's just not back yet. Once we get it, we'll give it to them. But we have to get our stuff first. It hasn't been processed before we can let them do it. And that drug on for months and months and months.
Do you expect a change of venue, Dave? Or
Not
a
at
motion
this-
for a change of venue?
Not at this late hour, no.
Okay.
I wouldn't expect it at this late hour. I mean, there's nothing that necessarily precludes them from doing it. I just, at this late hour, it would be kind of weird that they would. bring it up.
Right. I mean, I figured, based on everything that's going on with all the, claiming that there's witness tampering and whatnot, and the whole justification for locking Turtle Boy up would be because, he tainted a possible jury or whatever. That would probably be the reasoning for a request for change of venue. But you're saying that it's probably too late for that.
Well, this case has been pending since 2020, right? Am I
right?
Yeah. So, and
it's not the first time people have crowded outside of that courthouse.
Yeah, no, I don't see I don't see a motion for a change of venue coming from either side, from the state or. I did hear something about the Attorney General maybe stepping in to prosecute this, which would be a bad idea.
I heard that too.
Yeah, I heard that in the rumor mill. I don't know where that came from, but that would be a bad idea. You don't want to bring in a brand new attorney and replace. I mean, it would be a bad idea for the state, but you don't want to bring in a brand new attorney to try the case when you've had someone else working on it for so long.
Right, because it's just going to postpone the trial more.
I don't even know if it would postpone the trial. This judge seems set on this date, and so they'd have to get up to speed really quickly.
Right.
That was part of the filing for sanctions and to
I saw that
disqualify the district attorney, and then it would go to the attorney general. But
that's good for the defense. I said it would be a bad thing for the state. So,
Right.
But if the defense can force a trial date and force a new attorney cold to come in a month before trial, go for it, because that's a great move by the defense.
Yeah, and one of their arguments, I mean, of course, they're going to bring up like this federal probe into Morrissey and things like that. But also one of the things was that stupid ass statement that he made. It was the most bizarre thing I've ever, I didn't even know what to say. People were like, what do you think? I'm like, I don't know. It was just so weird. Like I was watching, I was like, this is so weird.
Let's watch it and we'll
so
comment
weird.
as we go on, because otherwise we'll be here all night. But yeah,
That's all right. I have plenty of beer, Brandon.
All right, cool.
Their argument is that when he made this weird statement that he essentially poisoned the jury pool. So that was one of, and it was unprofessional. It was outside of the rules of professional conduct for him to have done that, which I feel like I agree, just because it felt so weird.
Yeah, this whole case is insane. I mean, there's even a hot mic moment where the reporter from this channel right here at the end is like, I've never seen a circus like this in 110 murder cases. Like, it's pretty funny. They probably edited out of this, but Brandy Churchwell has it.
That's why
Brandy's going to be building Legos with me on January 2nd. You guys on the
Thank you. That's why we've asked for the communications that the Commonwealth has now agreed with. Our request is nothing short of critical to our defense, obviously, and it's based on Ms. Reed's constitutional right, as established in Davis versus Alaska, the U.S. Supreme Court constitutional right, that's recognized as the right to attack the credibility of any government witness, be they a government witness on behalf of the police and the investigation, or any other government witness.
Is Elizabeth Proctor a government witness?
She is not, but Jennifer McCabe is. And the communications that we're interested in are the communications that are concomitant between Elizabeth Proctor and Jennifer McCabe. We've established that there is a close personal relationship between
Elizabeth Proctor was denied, right?
And obviously Elizabeth Proctor and these third-party culprits.
It was
implicated in this case,
but
brought to the court's attention, the Alberts and the McCabe.
Go ahead.
The reason that I find this interesting is that the argument is not that it's not as much about, let's say, Jennifer McCabe as being their third-party culprit, but more about we need these communications to see or to be able to show that she is or isn't, maybe she's not, biased, so that we can discredit her as a witness. Meaning, if she is biased, she would say things.
She's a witness and communicating potentially with the wife of the lead investigator, right? And so
No, she's definitely communicating with the wife of the lead investigator. The issue is she communicating with the lead investigator? Like, there's
Right.
clearly a conflict of interest there.
but they
you know?
granted the one with regarding Proctor himself, right?
They did.
Yeah. So they're going to know whether or not a witness is communicating with the actual lead investigator. The question that's still out there is, is she texting the Proctor's wife while Proctor and his wife are lying in bed at night? And that's the thing that's not really going to be
Pillow talk.
available. Yeah. Yeah, husbands and wives talk.
Is this case pillow talk? And we have to assume that it is. I mean, let's just get real.
Yeah.
and
they might all be in the same bed. We don't know.
Well, and does Elizabeth Proctor have a certain type of sway over Jennifer McCabe, in the sense that she would obviously back her husband's investigation, obviously. So when they're talking about, let's say they really were just meeting because they're tired of the harassment or whatever, are they building up each other's hatred? I see this everywhere. Are they building up each other's hatred for Turtle Boy, and then that will carry over to make Karen Reed suffer? Because I see that.
Well,
all over the
that's
place.
their justification. That's their justification, is that Elizabeth Proctor and Jennifer McCabe are confiding in each other and comforting each other for all of the harassment and the intimidation that they've suffered via Turtle Boy. That's what they've.
Turtle Boy's great cannon fodder.
Right.
All their focus is on Turtle Boy. They've locked away Turtle Boy. Turtle Boy has done so much to hurt their case. And the defense attorneys, the ones that can really hurt them where it matters, are being completely ignored.
Right.
These guys are running around getting the documents they want. They're going to have a really good case when it goes to trial. And Turtle Boy's cannon fodder.
Right.
At this point. And, there's been all this talk about whether or not Turtle Boy's been talking with Karen's attorneys and stuff. It doesn't matter to me. But more evidence that he's cannon fodder, and let them be distracted by Turtle Boy all they want. And these guys are going to come around and kick their asses.
I agree. I've been saying since the beginning that his arrest and his charges are nothing but it's going to have the Streisand effect. They expected it to be bad, but it's going to be good.
I can tell you. So the Broken Baker, I don't know if he's still in chat. He's I've been streaming with him. He's been covering the Karen Reed case quite a bit. I haven't been until Turtle Boy was charged. And then all of a sudden I'm like, well, wait a minute now. A YouTuber blogger is being charged with witness intimidation. Let me look into this. That's how I got involved with this. It wasn't for Karen Reed. It was for Turtle Boy.
Nice.
And so it did exact, it is the Streisand effect. It brought this whole thing even more to light. And in fact, there's a super big YouTuber out of Michigan, Steve Leto, so like 500,000 subs or something like that. And I was just talking to him, and I brought his attention to Turtle Boy. And so it's spreading because of Turtle Boy, and because they arrested him and charged him. Otherwise, people wouldn't be talking about it as much.
Yeah. And no, Mello, I'll tell you, I highlighted that comment for a reason. Mello is not on the Epstein client list, and I'll tell you why. He couldn't afford it. So I don't think Mello has the money to be one of Epstein's clients. So just to shoot down that silly little comment.
Not with that suits. Or that suit, I should say, that one suit.
Yeah, dude couldn't afford to be on Epstein's client list.
That's the relationship, and that's the foundation of our request. This is so important that I'll bring it back to the court's attention, and the court knows this, that even the sitting DA, the elected DA, decided to weigh in on this issue of the relationship between the Proctors
He totally did.
and the McCabe's and or the Alberts. And he said there's no such relationship. Zero. This doesn't exist.
He said it publicly.
The word that he used was
in a public statement.
Any suggestion to the contrary that there's any kind of relationship between the Proctors and the McCabe's or the Proctors and the Alberts is a lie. His words.
Yeah.
So the DA himself has put Trooper Proctor's neutrality at issue, and he did it in the most public way possible. And I would suggest a clumsy way. Who was he talking to? He didn't come into this courthouse and address the court, as we've all done. He didn't address the court. He didn't address the Commonwealth. He is the Commonwealth. He didn't address us, the defense. What he did do is he addressed the public and the potential jurors, and that was by design. So he calls the evidence that we've procured and that we've presented to the court as lies. Well, let's look at those lies for a quick second. We have presented the court with photographic evidence, not something that we came up with, something they came up with. Photographs in Exhibit C in our moving papers. And I'll just cover a couple of those. There's a photograph that we presented that shows Trooper Proctor's mother, with a person by the name of Colin Albert pictured in the photograph, with Trooper Proctor's sister pictured in the photograph, with Chris Albert pictured in the photograph, and with Jennifer McCabe's own daughter depicted in the photograph. They're all together at a birthday party. These are close and immediate family members of the Proctor family, the Albert family, and the McCabe family, and they're all together and they're socializing. That's not a lie. It's a photograph.
Yeah.
And it's unassailable evidence of that relationship. There's a second photograph of
Like, what are they going to say next? That it was AI, that was reface, you know?
The court to note.
It's not her.
At a wedding together. They're in a wedding together, in the wedding party. There's a third photograph.
And when was that? When was that? When was that?
2012.
By the way, as
Shut
defense
up, you
attorneys,
know.
please
As the court just noted,
pray
that was
for
about-
evidence like this. I was just gonna say we
Right.
pray for evidence. Like this.
I would imagine so. I mean, you can't, like, dude, look
at
at
his
it
face.
here. Look. Like, how do you, I mean, if you're
He took
dealing
out
with
the
the
shot
jury,
glasses when he first saw those pictures.
He looks like he's like can't even believe that they had the audacity to, like, it's just it's like this stuff shouldn't even exist, and here it does, and like you're gaslighting us to tell us that that's not her. Like, what is it? Is it a robot? Like, I don't understand. And he's getting ready to make that really good point. But do you see what I mean? How she's like, and what was the date of that? What does it matter when the date was?
doesn't matter.
Can you explain what the date
Doesn't
matters?
matter. Yeah, it's, dude, look. It's right. Like, look at it. It's very funny to me.
To get to in a second is not just days old, months old, weeks old. This relationship is decades old between these families. There's another photograph that the court has seen, Trooper Proctor literally on the dance floor with Colin Albert. So when counsel for Elizabeth Proctor suggests, oh no, these relationships, you can't believe any of this stuff, just because someone happens to be at the same event does not thereby establish a relationship. They weren't just at the same event. They're in a wedding party together. They're standing on the dance floor, side by side, shoulder to shoulder, Trooper Proctor and Colin Albert. And then we see a photograph of all of them seated at the same dining room table. They shared a meal together. This is socializing. These are interpersonal relationships, and they can't change that. Trooper Proctor was seated at the same table, having dinner with Colin Albert, Chris Albert, and Chris Albert's wife, Julie. Then there's the Facebook post. And I will leave it at this. I'm not going to go through the entirety of my motion, but I would highlight the last point that I think should be highlighted for the court's attention, and that's the Facebook post. Trooper Proctor's mother refers to the Albert family as the Proctor's second family. So one might actually ask Mr. Morrissey, who's actually lying in this case? Is it us? We just presented the court with factual information that was procured off of social media that it's unassailable. It cannot be assailed. And the Proctors have known these people for, as the court just mentioned, by asking for that date for more than a decade. They've socialized with him, and his family considers their family to be so close and interconnected that they are deemed a second family to the Proctors. And who exactly are members of this Albert family and or McCabe family? Let's look at those members. Brian Albert, Nicole Albert, who is Jennifer McCabe's sister, Brian Albert Jr., Brian and Nicole's son, Caitlin Albert, Brian and Nicole's daughter, Jennifer McCabe, Nicole Albert's sister, Matt McCabe, Brian Albert's brother-in-law, Chris Albert, Brian Albert's brother, Julie Albert, Brian Albert's sister-in-law, and Colin Albert, Chris and Julie Albert's son. The McCabes and Alberts ostensibly are one family. They socialize within the same social circle, in the same familial circle, and that is who the Proctors have proclaimed to be their second family.
I mean, it's the whole clan, bro. It's not like there's like this one member of the family who's kind of cool with this other member of the family.
Right.
It's like these people are thick as thieves, for lack of a better term. They are just they're homies. It's family and family together, like as if they're one big family, especially if they're in a wedding party together. You know, I mean, it's so funny that they would try to deny this. Dude, hey, George Soros, I gotta tell you, I love all your money, buddy, but I I can't, I don't know what you're doing. But I mean, I wish I could help you, but I can't.
And if that weren't enough, we find out during the pendency of this case on September 25th, 2023, that one of those family members, Jennifer McCabe, who's the subject of great interest in this case and a primary person of interest in this case, is invited to Trooper Proctor's personal home for some sort of off-the-books meeting. Do we know about this meeting? Because Trooper Proctor, upon learning this, that Jennifer McCabe was coming to his house, ran back to the office and filed a police report, a supplemental report explaining this meeting, this off-the-books meeting.
That would have been appropriate.
No, he never disclosed it. We found out about
Right.
this because a concerned citizen happened to photograph Jennifer McCabe's car parked outside.
And kind of like it would have been appropriate if he actually reported every single time that he went back and found a piece of a taillight, which he didn't do.
I mean, it's not appropriate at all that she was there, period. They could have met at like the mall, but they chose to do it at her house.
His
but
house.
They shouldn't be meeting anyway. But regardless, let's say he walked in from work and she was sitting there, then that's what he should have did. Or he gets home from work and his wife says, I had, Jennifer over here, we were talking. He'd be like, are you stupid? Like, what do you mean you had her over here talking? And
If
then
we-
reported that too.
If we take this out of the context of this particular case, and these parties don't know each other, and we don't have this wedding that they went to 10 years ago or anything like that, I don't find it horrible that they went to the personal residence. I don't find that horrible. It's that within the context of all this other stuff.
Oh, my bad.
In the evening.
That's my fault. So you don't find it horrible. I mean, you understand that it's Jennifer McCabe who went to Michael Proctor's house, not the other way around.
Oh, okay. So the witness
Right.
went to
To the house of the
witness
lead
went to his
investigator.
Yeah,
personal
that's
house.
right.
Yeah.
Well, that
That's-
wouldn't happen if they didn't know each other, right? That's kind of the argument.
Who's letting a
Because why
witness
would a lead
or a
investigator?
Exactly.
A lead
Exactly.
investigator is not going to invite a witness over. Now, a lead investigator might go to the witness's house. That's where I thought was happening. So
Correct.
I'm mistaken. Nope,
No.
that's weird.
I don't even want
All
you
right.
to know where I live, let alone invite you inside my home.
Yeah.
Yeah, that's insane. Like, because I had to kind of double take, when I saw that. I was already kind of suspicious
Well,
of
because
everything.
I have like PIs that will go and visit with witnesses at their home and stuff like that. That's what I thought
Sure.
was happening. It's the other way
And it makes
around.
sense.
That's-
And if you want to make someone feel comfortable, if they've been victimized in some sort of way, I could see an officer going, "I'm going to come over to your house and we're going to talk." That I don't find that weird at all. But I found it absolutely weird that the witness would go to the trooper's house.
He sat on the lead investigator's couch inside his home where he eats dinner with his wife.
So insane. So insane.
I think we're
Thing
coming up on the
after
good
hours.
point he makes when he says
And the best that
about
the
Lally.
counsel for Elizabeth Proctor can muster in terms of an argument is to say, well, you know what, Your Honor, maybe he wasn't home. Maybe. Or maybe not.
What difference does that make if he was
Trooper
home?
Proctor isn't saying. And there's nothing in Elizabeth Proctor's motion to suggest that he wasn't home. Certainly his car was there. Elizabeth Proctor's car was there, and Jennifer McCabe's car was there. Was Trooper Proctor home? I guess I would answer that by asking the question, does it matter if Trooper Proctor was home? They've now admitted that Jennifer McCabe,
There
the
we
central
go.
character in the middle of this investigation, in the middle of this crime, was secretly meeting and or socializing with the lead investigator and or his wife in the living room of their home. And that, Your Honor, is a problem. And it shows more than a professional connection. It shows a personal connection. And according to the Proctor family's own counsel, Elizabeth Proctor's counsel, the subject matter of that meeting was commiserating about this case. They weren't talking about sports. They weren't talking about the weather. They were meeting about this case.
And you have to assume that they were meeting about that case. Like you have to assume it. Like,
Well, they were either meeting about this case, which would be weird for a lead investigator to invite a witness over, or they are friends, which is contrary to their position.
plain
Which
and
one is
simple.
it? Pick one.
Right, exactly. Like you're fucked either way. It's a bad
How
look
does
either
that
way.
not implicate Karen Reed's constitutional rights to this information. And to this day, the Commonwealth has yet to concede.
Actually, you're paying me. I don't know what you're talking about, but you're paying me. Bob Brown, thank you. Will, please tell your guests that you are taking the bar exam and will be doing the cross examinations at the trial. You broke the 911 recording and raised questions better than most lawyers. I mean, unfortunately, and I'm not going to insult the profession of an actual attorney that's sitting on my panel right now. I joked about that before, but you know,
Well, like I
being,
say,
able to, being able to ask questions and
most attorneys
That's the only
are
part I would be
bad
interested
at,
in.
Most attorneys
Right.
are bad at trial work. You know, it's a lot easier to pass the bar exam than it is to be good at trial work. I like to pretend that
No,
I'm
that's
good.
all I want to do.
You can see one of my trials.
just
It's
wanna
on
do
my
cross-
channel. But
I'll
I just
take
want
the
to do
bar
cross
exam.
examinations. I don't want to write anything. I don't want to study. I just want to ask the questions.
I'll take the bar exam in Michigan, and then I'll just come in when it's time to go to trial, homie. And I got you, bro.
Sounds
I
good.
got you. Thanks, Bob Brown.
What obviously is now sort of front page news that there is in fact a personal
Wow.
relationship between the Proctors and their
dude's killing
second
me.
family, the Albert McCabe family. But here's what the Commonwealth has said, even though they haven't made that connection or that concession.
Oh yeah, right here, right
October
here.
3rd, 2022, Mr. Lally made a couple of points, eloquent points in this courtroom. And what he was doing when he did it in October was illustrating what an inappropriate relationship would look like if one existed, what a conflict of interest would look like if one existed. And he said, quote, Michael Proctor has been fully vetted, end quote. He said, there's no conflict of interest here because it's not like, quote, these people are socializing together, end quote. He said, it's not like, quote, these people know each other, end quote. And he went on to say, it's not like, quote, these are people that Trooper Proctor has been over to their home, end quote.
Sorry, I had to
good.
do
A
it.
conflict
That was good.
it would surely illustrate an undeniable bias. And those comments, Your Honor, I would suggest have not aged well. And I would wonder at this point if the Commonwealth hasn't adjusted its stance, which is why the Commonwealth is now conceding that we're entitled to these communications. And that turns on the question of asking, how could Trooper Proctor be expected to adequately and honestly investigate this case as the lead investigator, and also investigate the Albert McCabe involvement in this case, with his history of an interpersonal relationship and allegiance to those very people, the very third-party culprits, the very people who should be suspects in John O'Keefe's murder? And the answer is he cannot. And since the authorities, including Michael Morrissey, apparently have vouched for Trooper Proctor, my client, our client, Ms. Reed, is entitled to question and to test that voucher. And that's what we're seeking to do with the communications between Elizabeth Proctor and Jennifer McCabe. And insofar as that request is concerned, it's unquestionable that there are privacy interests at play, but I would suggest the following: that the constitutional due process rights of any criminal defendant in any criminal case hold a paramount significance because they form the very backbone of the justice system that this court presides over. And protecting those rights, such as the right to a fair trial, such as Ms. Reed's right to the presumption of innocence, that ensures an equitable trial and an equitable process. And while privacy rights of Elizabeth Proctor, a third-party witness, are obviously an element of concern and consideration for the court, they must yield to the imperative of a fair trial. And that imperative means Ms. Reed's ability to confront and properly cross-examine all witnesses, including Jennifer McCabe, including attacking the credibility of government witnesses, including Jennifer McCabe, based on bias, and that is fundamental to our justice system. So striking this balance ultimately upholds the integrity of the very system that this court is making sure exists and continues throughout the process of this trial. Elizabeth Proctor's privacy rights, while they exist, especially in light of the narrow focus of our request, are vastly outweighed by our client's right to a fair trial. And with that, Your Honor, I'll submit.
Ms. Proctor, counsel for Ms. McCabe. I got an appearance this morning of counsel for the troopers as well. Counsel for the troopers going to address us.
No, that's in
Okay.
reference to my motion.
Okay, so I will hear counsel for Ms. Proctor.
Thank you, Your Honor. Good morning.
Good morning.
Andrew Kettlewell for Elizabeth Proctor.
Good morning, Mr. Kettlewell.
So this is not
This
a
guy was
balancing
shitting a
test
brick.
between the defendant's right to a fair trial, which is obviously constitutionally protected and paramount to our system, and Elizabeth Proctor's privacy rights.
This is a request to bring evidence before this court for the purpose of trial under the mechanism of Rule 17.
Wait, wait.
Not within the
I'm
framework.
like, I'm looking at his hair. What animal is it? Like a rooster? Look at that little piece of his hair.
In his defense, he doesn't look at it from that angle, right? He's only looking at it like right in the front. He's like, it's spiked up. It looks good.
He missed the spot. Oh my god.
But as it relates to the standard here, the question is whether the defendant's request satisfies the 4 prongs of Lampron and the basis of Rule 17. And the defendant's request, I would submit to the court, fails on 3 of those 4 prongs. And I'm not going to belabor the facts underlying this whole situation. My brother laid out his case. That is laid out quite clearly in his affidavit as well. What I would say about the facts is, with regard to the first prong of admissibility and relevance, while hearsay that is reliable is certainly sufficient as a basis for a subpoena to issue, hearsay which is not a basis for a subpoena to issue. And in this case, my brother's affidavit essentially amounts to a large collection of conjecture and allegations which are not supported. With regard to the motion and the opposition that I filed, I appended an affidavit that lays out the basis for why I assert what I assert in my affidavit. And that's essentially conversations with individuals who have personal knowledge of where Michael Proctor was on the night of September 25th, 2023, individuals who have personal knowledge of the connections between, as my brother says, these 2 families, and who have personal knowledge relating to the actual photograph that my brother didn't mention in Exhibit C of his affidavit of Michael Proctor with 2 children who are still minors, who are not children of Jennifer McCabe. Essentially, the relationship between these 2, quote, families is a distant connection that involves 5 separate steps of relationships between, I guess I'll call them relatives. Mr. Proctor's sister has a friend whose sister is married into the Albert family.
You're reaching, bro.
Albert, not Brian Albert. And so what brought these different families to a wedding in 2012.
This is a mini Lally. He's
was
mini
the fact
Lally.
that
He's Lally
Ms.
before the
Proctor's-
Commonwealth
Mr.
sucked all the
Proctor's
life and
sister,
hair out of
Ms.
Lally.
Proctor's sister-in-law was getting married, had her friend at her wedding, and her friend's sister and her family
Today,
also
Junior!
attending that wedding. The fact that Colin Albert and Michael Proctor were in the same wedding party, I think is mitigated somewhat by the fact that Colin Albert was about 10 years old at the time and served as a ring bearer because he was a child. So the connections that my brother tries to lay out in his affidavit, I would suggest are not what that affidavit makes
Does he
it
not
seem.
know his name?
I mean,
Regardless of all of that,
get the fuck out of my face, dude. Like, you couldn't find a cuter kid to be a ring bearer, bro. Like, that's like, you're going to tell me essentially that the reason why you picked him basically was because he was just a cute kid that you happen to know. Like, no, you picked him because he was close to the family. You know what I mean?
You don't pick
like,
a random kid off the street, right?
Get the
There's
fuck
some
out.
connection there.
Distant to this person, distant to that. No, man, you picked him because he was that important to you, and that's the reason why anybody picks a ring bearer, dude. Like, get the fuck out of here.
Someone was
and
asking
also
about the brother
avoiding-
and sister comments. How they call each other brother, as my brother said. In Michigan, it's more common to say brother counsel or sister counsel. I use the term, opposing counsel or defense counsel or plaintiff's counsel or something like that. But
Which
I
is what
usually
you do on
do it
TV.
because I forget the attorney's name. I'm horrible with names. So I always say
Nice.
like,
Dude.
opposing counsel here, said something, blah, 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 whatever. And it's usually because I forgot their name.
See, that's why I couldn't be a trial lawyer, because I'd be like, dude over here with the big mouth.
Bruh.
Got my cheat sheet with everyone's names.
Yeah, like, Your Honor, as our beloved dickhead just said, there's no way. I could never.
I love how this guy is totally avoiding talking about what Proctor's mom said about them being a second family. Like he's doing all this extra stuff. Like it's the brother's, sister's, friend's, husband's, mom's cousin. And so they're not really friends. but he's like forgetting that Michael Proctor's mother said that they were their second family, and he's avoiding commenting on that.
Yeah, it's a classic bullshitter tactic. It's, let me just.
So are they
throw
going to
a
put
bunch of
Michael
shit out there.
Proctor's mom on the stand and be like, "Ma'am, why did you say that?" And she's just gonna be
Right.
like, "Oh, I only like one of them. I like one, but I didn't want to be rude and exclude the whole family, so I just lumped them all together."
Right. It's so Aunt Bev can just sit there and just be like, oh, okay, like how long before he's done? You know what I mean? And like it's stupid. Like it's silly. This guy's just given a whole bunch of double talk that none of it, like 80% of it is not relevant.
Yeah. He's just
issues
making it up.
on
He's trying to minimize it.
admissibility and relevance
Right.
under the first prong of Lampron. And the reason for that is the defense actually includes a description of this September 25th meeting between Elizabeth Proctor and Jennifer McCabe and why that meeting occurred in a state police report that it actually appends to its motion. And whether or not a court down the road agrees that that area of testimony is valid grounds for exploration for impeachment of Ms. McCabe, what's occurring here is that the defense is attempting to use that as a basis to go get another layer of even more extrinsic evidence on the hope that something that's in the phone of an unrelated third party might impeach Ms.
He calls
McCabe
it a
in an
fishing
area that is
expedition,
already
I think, in a minute.
potentially a grounds of extrinsic evidence for impeachment. And that is not what is permitted under Rule 17.
They say that in
is
every
hope,
response
that
to
is a
every
conjecture,
motion.
and
Yeah,
that
it's
is
not a fishing
not the
expedition if
purpose
you
of the
have
rule.
something to back it
And
up.
I'm not going to belabor the point for the court because I know the court is very familiar with Rule 17, but the purpose of the rule is to bring into the court for inspection and for purposes of trial records which are going to be admitted or are likely
Right,
to be
I
admitted
mean-
at trial. It is not for discovery. It is not.
It's not a fishing expedition if it's like a mile-long net.
Yeah. I mean, that's the thing. So the court rule has some merit behind it because they don't want people just grasping at straws and throwing out irrelevant evidence and wasting time and frustrating the process and doing that. But when you have something to support, like, hey, here's a picture of them at a wedding, we think there might actually be a bigger connection, and we can use that to impeach the state's witnesses. And my client has a right to impeach the credibility of the witnesses. So now that we have this piece of evidence, let us go see if there's more, because my client has the right to impeach.
And it's not just the pictures. She was at his house. And there's
Yeah.
like no reasonable explanation. I mean, I don't know. I guess I don't understand why they're still arguing it. Like, I'm seeing people now say,
I mean, at the end of the
"Oh,
day,
well,
it's his job to argue it, but at the same time, it's like, dude,
I've been in this position too, where I have to argue things that I don't want to argue, or I don't like truly believe in. And sometimes we do it for different reasons, but it's hard to be in that position where you're arguing something that you don't believe in. Remember, I had a judge once that like Socratic method me. He was like, well, what about this scenario? And what about that scenario? And I had an answer all the time for him. And then at one point he's like, well, what about this? And I was like, Judge, I don't know. And he's like, that's why you lose. And so it's tough to be in a spot like that where you just sort of kind of run out of arguments. So I feel for him right now, but phone it in.
Yeah.
Reddington was
Well, he
basically
kinda
like,
is,
yeah, no, I don't have anything to add. I'll just go with what he said.
Yeah, I mean, you have to. I mean, your job is to litigate, which means pretty much argue with the law, and
Exactly.
you have to argue. So it's your job to argue. If you just go, dude, you got me, you're not really fulfilling your duties.
Well, that's when you usually hear the attorney say, I'll leave it to the discretion of the court. They kind of ran out of arguments and they don't believe in their argument. They're like, just leave it to the discretion of the court. And they're
Right.
hoping that the court, sides with them.
I wonder if they specified. Now, I know when they talked about the communications that they have to turn over, they did specify basically like any forms of any apps, Facebook Messenger, text messaging, phone calls, anything with Proctor and Jennifer McCabe and
Well,
all
this
them.
should be a data dump through what is it?
No,
Silverlink or something like that.
screenshots, dude. They're
turning
going
over
to turn over screenshots. Yes.
Well, there might be
Yeah.
another motion. I don't know.
Yeah.
That's
No. screenshot.
then-
That was the Commonwealth's basically like, you know, if they're gonna do it, then they're gonna send it over in screenshots.
As a defense counsel, I would make sure that one of my people is there when those screenshots are taken. I'm not going to trust them to do the screenshots.
Yeah. Well,
Yeah.
and if
Well,
you're
what if
doing
they're
screenshots,
deleted?
they've already deleted
Why are
it.
we not doing? Why are we not doing a not SoberLink? What did I say? SoberLink. The data dump software. I can't remember. I'm skipping my.
Oh,
Can't remember
Celebrate.
Celebrate. Yes. Why are they not doing a data
Yeah.
dump through Celebrate? Why is that not happening? That's what needs to happen. They're doing the screenshots.
Well,
Well,
they're
we
trying
found
to, the
phone
Commonwealth is
records
trying to
already.
argue the Celebrite data and what it does, which I find hilarious. Is now, correct me if I'm
They're
wrong.
trying to say
but
it's not credible.
They're trying to right. They're trying to say
is
that
for their data.
that there was 2 windows open or something to that effect, and that the timestamp of 227 wasn't actually at 227. It was later when Karen Reed supposedly, because she had a window open or something to that effect. And all I could think of is, well, if that flies in the court, won't that set a precedent to where anyone convicted based on Celebrite evidence, wouldn't
what
they
I
be,
would do
wouldn't
if-
that be
if-
ground for a new trial for them?
If money wasn't an issue, I'd be having a PI sitting in on some of the trials that these prosecutors are conducting with Cellbrite data, and I'd be writing down and getting transcripts, and I would be arguing like, so when you said this other case that this stuff is totally reliable, were you lying then or are you lying now? You know,
Right. But I mean, am I wrong, Dave, specifically for you? I mean, wouldn't that set a whole new precedence for Celebrite data used in the past to convict?
no,
anyone in a-
it wouldn't create a precedent unless it goes up to the Court of Appeals and the Court of Appeals says something, because at a trial level, it doesn't set precedents. And what the state is betting on is the fact that juries are lazy and they're going to convict. And it doesn't matter. We can throw enough shit in the air and the jury's got to convict. It doesn't matter that we're arguing this, because that same jury is not hearing our arguments in the other courtroom. You know, so they
Well,
can argue out of both sides of their
I'm gonna
mouth in
read-
different courtrooms. That's why I said you should have like a
wanna
PI
read-
sitting in there. What are you going to read?
I want to read to you what they're going to do, what they said they're going to do with this if it did get granted. And they said the Commonwealth's position is premised on the defendant's narrowly tailored and date-restricted proposed order for communications between Jennifer McCabe and Trooper Michael Proctor, Jennifer McCabe and Elizabeth Proctor, and Trooper Michael Proctor and Brian and/or Nicole Albert, where the request is directed at the individuals as both the third-party subject and record holder. The order does not extend to records maintained by any company or corporation. The Commonwealth anticipates that if records do exist, the scope of their production would be consistent with screenshots or printouts of the relevant communications. Notably, the proposed order does not seek production or examination of the individual's cell phones or electronic devices. Rather, the order is incumbent on the third-party subjects to provide documentation of any relevant communications. So is it possible
the
that they
third
already know?
parties, the third parties are supposed to take screenshots and produce them. That's it.
Yes.
That's
Is it possible that the defense knows of communications that exist and they want to see if they'll turn it over?
That's not bad. That's not bad. Yeah, I mean, you could be setting up a situation where they screw themselves either way. Either they turn over the communications that they know exist and it is bad for them, or they don't, and you can impeach them during cross-examination and it's bad for them.
Yeah.
So they very much they could be setting themselves up, and that's not uncommon. That's a good way to do it. You know, this is going to trial. You know they're going to be called. You know what they're going to testify to, and you're just setting up a way to impeach them.
Now, but they wouldn't have to turn that over to the Commonwealth, right? They would just be able to keep that information to themselves until she's
Oh.
asked about it.
Yeah, well, let's assume they have Cellbrite data already. I know they do, right? So they say they have stuff like that. That's why I said, like, you know, my little smoking gun is page 77 of this 140-page document that I sent over. You don't need to know what my strategy is. I just need to send you the documents. And so now if these screenshots are turned over and they have the documents that conflict, if the state doesn't catch it and the defense crosses on it, then they're caught off guard. And they don't have to say why they're going to be introducing something. They'll say, this is the evidence that we plan on introducing.
I'm just
That would
wondering
be
if that's why
work
they're
product, which is confidential. So technically it's
Yeah.
confidential. They can't turn that information over. The state can't ask for it. They're not allowed to turn it over. It's the client's privilege.
It would just make more sense that they'd be okay with these screenshots, you know. The fact that they don't put that in the proposed order that it would come from the company, I'm just thinking they're not idiots. So perhaps they already know of communications and they're leaving it entirely up to these third-party people to hand over whatever it is that they know exists. That way, if they don't, it turns into, like you said, like an impeachment thing. Like, well, we knew that it existed. She kind of like the deleted when she deleted all the calls and
Yeah, but what are the chances of that?
I mean, again, we're always litigating on a budget, right? I don't care how much money you have. There's value litigation. I think somebody said O.J. Simpson, for that trial, he spent $9 million on his defense, but the state spent $12 million. The state's
Money well
always going to
spent.
spend more than you, right? The state's always going to spend
Right.
more than you. It doesn't matter. So you're always on some sort of budget, and you're looking at what's the best allocation of those resources. And so if they've got something, they've got enough, and then they can force them to produce something, and they can catch them in some lies that might be enough to discredit the whole thing. And they don't need all that additional data. All right. This might be value litigation.
Yeah, I plan to, Paul. Yeah, I'm a big fan of the of how I can't stream it right now, but supposedly
Once she
Coffin
makes it on
offers
Twitch
on
TV.
panel. I'm dying to know how she feels about being bested by Mr. GED here.
There's no way she's gonna say that.
I mean,
I'm sure she's doing the whole thing that everyone else is doing, saying, who cares that they're gonna have to turn that stuff over because none of those communications exist. Well, how the fuck do you know that?
right.
That those communications don't exist?
Either you
So I'm
don't
sure
know what
she's-
you're talking about, or you're in contact with someone in the
Correct.
Commonwealth. So, yeah, it's insane.
Not for exploration, whether or not that exploration the defense believes is part of its case or not. It's a question of, are those records going to be admitted at trial, and do we know they exist? And the defendant hasn't made out any of those factors at this point. The defendant is essentially assuming that there are records, does not know what is in those records, and as a basis is requesting. And that is not a Rule 17 motion, that's a discovery motion. And with regard to that kind of last prong of Lampron, I think the defendant makes clear her basis for the request in counsel's affidavit, as I cite in my opposition. And that's thus the communication surrounding this, parentheses, and other meetings, which again, the defendant has no basis to believe there might even be other meetings, close parentheses.
See, now you guys got me thinking about this dude's hair, man. Like, I can't stop looking. Just take a number.
No,
just take a number
like
4
a
to that
cock,
bastard,
right
bro.
there.
Just take
It's
a
a
number 4 to that
cockatiel.
bastard, and that's it, dude. Like,
He needed some Ollie's gel. He should have said something
let
before he
it
walked
go.
May reveal information.
It don't look
necessitating
much
further
better
pretrial
straight
motions,
ahead, so-
including a motion to
No.
dismiss based on extraordinary governmental misconduct. And that's the
Like he tried to
purpose
comb
of
it
this
over.
Rule 17 motion, but that's not the purpose of Rule 17. The purpose of Rule 17 is to bring into court relevant and admissible records. These records are not relevant to an issue in this case. They would not be.
Now, is he
admissible under any
fishing
rule of evidence?
for? Is he fishing right now to find out what they want to use that evidence for? Because you just stated, Dave, that they don't have to say what they're going to use it for, or how they're going to use it. They just have to. They just.
Well, I
have
mean,
to put
all
it
they have
forward.
to say is basically it's there to impeach the credibility of the witness, and this entire investigation is to establish that there's a bias here, which implicitly goes to bias and potential, willingness to lie on the stand. Essentially, that's all they have to say. It goes to bias. It goes to, and everyone knows that bias. What they mean by bias is that they're going to use this stuff to impeach these witnesses with, and discredit their testimony. And so it goes to the weight of it. It attacks essentially the weight of the witness's testimony. That's all they have to say. It goes to bias. There's a bunch of like, everyone knows what that means underneath. And so they don't need to go any more than it leads to bias or it shows bias.
Okay.
And based on what's actually asserted by my brother in his affidavit, nothing about that assertion meets the Rule 17, meets the requirements of Rule 17. The fact that communications may reveal information right off the bat fails. And the fact that they are looking for these records.
His voice is cracking.
As they might necessitate further pretrial motions, including a motion to dismiss, is entirely anathema to Rule 17, which is designed to bring records into the court for purpose of trial. And so based on all of those and what I lay out in my papers, I would ask the court to deny the motion.
All right. Thank you very much. Mr. Reddington, do you want to add anything? I do have your motion to join in the opposition that was just argued by Mr. Kettlewell, but do you want to add anything to that, sir?
No, Your Honor. What I would do is basically, as I indicated in the motion, is join in on the motion, noting the objection of Jennifer McCabe, obviously asserting her privacy rights, obviously suggesting, as counsel just did, that this is a clever maneuver to try to kind of weaponize Rule 17 to turn it into a discovery motion. We all know that the September 25 meeting was about harassment and what these two women had been going through on the news media with the extreme harassment that they were suffering as a result.
Extreme. Oh my God, they talked bad words about me.
Also, he called him news media. He didn't call him a blogger.
May reveal, and they
Right.
probably would show, which is what's in the motions that's before the court, clearly shows that there's no basis, there's no factual basis to determine that these are relevant material records other than speculating that they may reveal. Just like the allegations that the photograph of the two young kids would be Jennifer McCabe's daughters, and they're not. And
Like, I wonder how many of the other witnesses,
they know whose kids these are.
how many of the other witnesses, against Turtle Boy, the victims of Turtle Boy, how many of them got together over a box of wine and said, "Oh my God, are you dealing with what I'm dealing with? Oh my God, yeah, I'm totally dealing with the girl. I love your blouse."
You know, there's a
this
group
and that."
chat going around.
Get the fuck out of my face! Like, I mean, get out of
Well,
my
these
face with
guys,
that.
you know, they're so their egos are so sore. You can tell when they lash out at Turtle Boy and everyone else. You know, it's like a unintentional response to a guilty mindset, right? And
Totally.
yeah.
It ripples out to Twitter, dude. Like I love the people on Twitter because they make it personal. They start taking personal jabs in their argument, and it's
I
just like,
love
I already
making
won.
things
I
personal
won.
on Twitter. I don't care. I don't care at all. You guys, I had a guy call me a homeless internet lawyer in my chat once. And I pulled it up and I said, "Thank you. This is the greatest gift ever." So I love the trolls, but people take it so seriously and they get so mad, and I get so much joy out of it. I don't know if I'm sick or what's wrong with me, but
I had some. I blocked.
We
I had
suffer
someone
from
that
the
has
same
been blocked
ailment,
for
I
months.
guess.
Yeah,
Sorry, what
dude,
were you saying?
they've been blocked for months. They comment on everything I post. Still blocked. Freaking weirdos. I started just muting people, and I just watched. The trolls are the best.
I mean, no, I'm
I
telling
don't
you,
mute anybody. I love it.
You got Coffindoffer who's blocked me finally, and now she's
Coffin licker.
tagging me. Yeah, now she's tagging me and shit after she blocked me. Like, tell me that I didn't get to you. Tell me I got to you without telling me I got to you. You know
Well,
what I mean?
I haven't been blocked by her yet, but I don't come right out and like attack her. I'm like, so what you're saying? I use the Socratic method, which is extremely frustrating to people that don't want to be challenged. Use the Socratic method. They're like, well, how do you explain this exactly? If this is what you're saying.
I asked her what cereal I had to buy in order to get a badge from the FBI that she got. That's what I asked her. But, you know.
The FBI Academy is not hard, people.
Apparently not.
That they're children, but nevertheless, they consistently suggest that this is showing that he's sitting there with these two kids that are the McCabe's children, and therefore, as counsel argues, this is evidence of
No, only one of them is her child,
governmental misconduct, which is a
and it is her
wild,
child.
Accusation to be making at this point. And I suggest to the court that weaponizing Rule 17 is not proper. I join in the government's request initially objecting, And the fact that the council has indicated that the government basically concedes and assents and does not oppose should not interfere with Your Honor's analysis of Rule 17 as opposed to any Rule 14 or any discovery motions that would be appropriate before the court. Thank you.
All right. Thank you very much. Do you want to respond, Mr. Jackson, before I hear briefly from the Commonwealth?
Very, very briefly. Your Honor, I would simply, to the microphone, I would simply note as to my brother's arguments, eloquent as they may be, they missed the mark. Obviously, this is relevant and admissible. Again, I don't believe that Elizabeth Proctor has standing in the court to actually argue Lampron, but since it was brought up and since that seems to be the foundation of her argument, I do want to address one point. There's a case that was cited by my brother in his moving papers called U.S. versus Abel. It's found at 469 U.S. 45. It's a 1984 case. It does not stand for the proposition that is propounded in the paperwork. Indeed, that is a federal case, not a state court case. That's the first line of distinction. Second of all, it is a mischaracterization of the holding in Abel to say that the scope of impeachment is the outer limits. The scope of impeachment is limited to the outer limits of taking the witness's word for it. And I would simply bear upon or ask the court to review the actual holding in Abel. Justice Rehnquist does not state that the scope of impeachment is limited to, quote, taking the witness at the witness's word or taking the answer of the witness, end quote. But rather the court specifically held that it's permissible to impeach a witness by showing his or her bias. And that's all we're seeking to do. In the court's words, Justice Rehnquist's words, quote, a successful showing of bias on the part of a witness would have a tendency to make the facts to which the witness testifies less probable in the eyes of the jury than it would be without such testimony. And that's found at page 51. Contrary to counsel's misunderstanding of the holding of Abel, our impeachment of this witness is not limited to taking Jennifer McCabe's word for it. We're entitled to extrinsic evidence about her bias, about her lack of neutrality, about her attacking her credibility. This evidence is clearly relevant, it's clearly admissible, and the Commonwealth concedes as much in its opposition paperwork. And with that, I'll submit.
Mr. Kettlewell, did you need to respond in any way? Okay, sure.
So I'm not going to debate Abel because the court can certainly read the case. But essentially, it's the defendant's burden to meet Lampron. The defendant bears the burden to get the court to issue a subpoena and has to show all four of those factors. And it's not about whether the Commonwealth objects or does not object, and whether I have standing beyond an issue of privacy or not, which I would argue that a third party whose records are being sought certainly does. It's a question of whether they have met those elements, and they have not.
All right. Mr. Reddington, did you need to add anything to that?
No, Your Honor, I'm good. Thank you.
Okay. All right. Does the Commonwealth want to argue this in any way?
Just briefly, Your Honor.
Okay.
This guy.
Here we go.
More beautiful hair. Look at that.
Do they do they go to the same barber? Like, what the fuck is going on?
Assent does not concede.
They walk in the morning like, nice hair, man. Nice
Relationship
hair.
or whatever that is being termed as a close personal relationship. The relationship, as the Commonwealth understands it, between essentially Trooper Proctor and Ms. McCabe is that Trooper Proctor has a sister who has a friend, who has a sister, who has a husband, who has a brother, who has a wife, who has a sister, who is Jennifer McCabe.
All right, so that's
That's
bullshit.
just fucking
right there. I
dramatic.
hate that
What?
shit.
After
Yeah.
apparently
Hate that.
scouring social media, and there are exactly zero photos the council has produced of Ms. McCabe and
do it
Trooper
all the
Proctor
time. I
pictured
hate
together at any point in time. And essentially, what you have to
What the
establish
fuck
a
are you
close
talking
relationship is a wedding party from a decade ago, and some photographs of Trooper Proctor with children purported to be Ms. McCabe's children, which are not Ms. McCabe's children. But given the limited scope of what is being asked for, the Commonwealth is not opposing the motion, but would obviously request that if the court were to allow the motion, that both sides would have equal access to inspect and copy whatever screenshots are then provided by the record holders, that being the third-party witnesses. Thank you.
All right. I'll take this under advisement. Mr. Reddington, you're free to leave, but thank you for attending. You're free to stay too, but all right. So now we'll do the motion regarding the Commonwealth's motion for protective order pertaining to the DNA profiles of the investigating law enforcement officers. So I'll hear from the Commonwealth first, then I will hear from counsel for the officers, and then I'll hear the defendant's opposition. Who's arguing this for the defense?
This was really all a big nothing
Okay.
burger
All right.
because they didn't
Right.
realize that they agreed on
Mr. Allen.
everything.
Yeah, they agreed on everything. They just didn't know they did.
Yeah.
This is
So,
what we talked
Your Honor,
about
just
earlier.
to clarify on this, just a point I think maybe misconstrued based on the defendant's opposition. This is not a situation in which these troopers have consented to anything. at this point.
Right,
The purpose of
Ludus,
filing the
exactly.
motion was to try to gain
Thank
some
you.
guidance from the court as to how
Someone
mechanisms
said
will be
earlier he
confirmed with
looks
the
like he
collection of
smells
DNA,
like
the
cigarettes
retention of
and double
DNA, the
makeup.
destruction of DNA, and the timing of the results prior to
This tie is a
either to the
little,
proctor
yeah,
or Sergeant
messed up.
Buchanan's consent in
Yeah.
relation to the taking of any bugle swab. So how this sort of arises is there is DNA reports in relation to the taillight of the defendant's vehicle. There are 3 possible contributors to that DNA mixture.
They basically
One is,
argue for a
properly
half hour and
identified as that
realize
of the
that they're
victim, John
arguing the
O'Keefe.
same
2
exact
others
thing.
are unknown.
Right.
There's been rampant
This is
sort of
this is dumb.
speculation,
This is just
accusations
miscommunication.
levied against these particular troopers in regards
Let's
to
just move this along.
contaminating evidence.
No, you
I
can
was
listen to
hoping
it.
that's
This
what
is
you would
really
do. I didn't want to ask you to, but I was hoping
Yes,
you'd read
they
my
end up
mind.
in the same spot. They agreed that the DNA profile is going to be shared. They're not sure how long it's going to take for the lab to do the comparison, but they're all going to
Good morning, Your Honor. Thank you for hearing from me on behalf of
And
Sergeant
basically,
Buchanan and
Bev
Trooper
was like,
Proctor.
just take
In
the
the
samples,
discussion as her
like
privacy
today,
interests
like
as it
right
relates to the
away,
common-
and then we'll figure the rest out. That's what she said. That's basically what this came to.
So this is Bukaki's lawyer, I think,
And Proctor.
and Proctor's. Okay.
Well, it's a motion for a protective
Proctor
order.
the him,
The
not the
proposed
her,
protective order
because
strikes a
Right.
balance
her
between
attorney was
protecting the
just on
sensitive
the
and
Zoom.
Yes.
Right.
Yes.
personal DNA information.
Well, no, that was McCabe's lawyer. That was.
Oh, was
that
it Jennifer
No.
McCabe? No. That was Proctor.
No,
It was
Sue-
Elizabeth Proctor, attorney.
I specifically remember him. I could be wrong.
The-
I mean,
When
I
he
don't
first
know.
came
It
on
one
and
on
everyone
Zoom.
was yelling over Zoom, he was like, attorney,
Yes,
whatever his name was
that's-
for Elizabeth Proctor.
Reddington. No. Yeah. So the one on Zoom was Reddington. He is McCabe's lawyer. The one
McCabe's?
on Zoom.
Right. Yeah,
Oh,
that's what
okay.
I was saying.
I'm
The
sorry.
one
then
that was
I'm mistaken.
standing here physically is Proctor's. The one with Lally hair is
Okay.
Proctor's. Elizabeth.
Right.
This is
So Proctor's attorney is
This
the one I
lady
sent
rep-
you in DM on Twitter.
yeah.
Yeah,
This lady
that's what I was
represents.
saying.
I
I
guess, like,
could have sworn I specifically remember him saying that he represented Jennifer McCabe and he was
Okay, I apologize.
out of the country.
These freaking names, man.
Yeah,
I can't keep track of
It
these
happens to me too,
New
man.
England names. There's so many of them, and they pronounce them weird.
You can thank Turtle Boy for all this shit.
I know, right? He came on my stream
Yeah.
and we were trying to go through the names, and I studied for like 8 hours. I had pictures, like flashcards with names underneath them. Oh my god, I couldn't get it.
Of 2 individuals who are not alleged to have had anything to do with the death of John O'Keefe, while giving all parties access to the resulting scientific DNA analysis. The defense's opposition casts the proposed protective order as allowing the Commonwealth to obtain, test, and analyze the samples without giving them the same opportunity, but that's simply not the case. There are areas of significant agreement between the parties here. Both parties are willing to have an independent law enforcement officer obtain the DNA sample. Both parties are willing to have an independent lab develop the DNA profile and conduct the comparative analysis. Both parties will receive the same
This lady's
report
effective.
and
She came in and
underlying
she's like, "Why are we even here? You guys agree
Once
on
an
everything."
independent lab
And then the judge
Yeah,
is like,
I-
develops the DNA
yeah.
profiles, Your
Okay.
Honor, there should be no need for anybody to have access to the sample thereafter. And with an independent lab conducting the comparative analysis, there should be no need for anyone to have to conduct further testing. And finally, Your Honor, once the trial is over, there should be no need for those DNA materials to be on file. And as Mr. Lally said, the legislature has provided a mechanism for obtaining third-party DNA post-conviction. So there's certainly a safety net there if the DNA is needed post-trial. Your Honor, protecting the troopers' DNA samples and profiles through these procedures and protocols poses no violations of the Commonwealth's mandatory discovery obligations. The Commonwealth and the defense would be on equal footing with regard to the troopers' DNA evidence. Each party is free to argue the implication of the results at trial as they see fit. As Your Honor can appreciate, my clients are under no obligation whatsoever to provide their DNA in this matter, but they seek to take steps to demonstrate the integrity of their handling of the taillight evidence. In order to provide consent knowingly and voluntarily, they're looking for certainty surrounding who has access to their DNA, how their DNA is handled, and ultimately how their DNA is disposed of. On behalf of my clients, Your Honor, I respectfully request that you issue the protective order proposed by the Commonwealth.
All right. Thank you very much. Mr. Yannetti, it sounds when I read
Yeah,
your,
you guys are
text,
right.
like,
Like,
no
I mean, and I went
response
over
to
this
that.
last night because Sleuthy added this to the filings in the spreadsheet, and I mean, they're not trying to like exploit their DNA profiles. They're just trying to match them against any other DNA that's on
the evidence.
Yeah, and I think in like
That's
the next
it.
few minutes, they realize that they're arguing for the exact same thing.
Right. Yeah, it's silly.
Did you when you filed it?
I did not, and quite frankly, hearing the argument from both counsel, I think there's even more agreement than I anticipated.
Okay.
So,
Right,
Your
there
Honor,
you go.
Disagree with.
Okay, so our position, Your Honor, is at this point, with regard to the DNA samples versus the DNA profiles.
So where are you in your opposition? What page?
So I'm actually going to the Commonwealth's motion itself with regard to how the DNA samples and profiles will be treated.
Okay.
We did not realize that the Commonwealth was drawing a distinction between the actual samples themselves and the profiles that were generated. It was our understanding that the Commonwealth was seeking to prohibit the defense from having access to either. But I've just
Okay, but they're not.
Exactly. I've heard Mr. Lally say today that they will turn over the profile to us. That satisfies us.
Okay.
There
I
you
have a
go.
question for you.
Yes.
Since you mentioned Bodie Laboratories, you're the first one that mentions it in the pleadings. How long will it take?
We're not the first ones that mentioned it. The Commonwealth mentioned it in their motion, and we agreed to that.
All right.
Do you even read the motions, Bev?
Your Honor, it is one of the alternatives.
Yeah,
that the
I know.
Commonwealth had. I'm sorry, I can find
Okay,
them.
so we need to find the paper number. All right, but we need to know how quickly that can be done, and we need
Yeah,
to
this
see it
right here.
expediting it.
Typical for Bodie, just because I've recently gone through that with regard to the hair sample.
Right.
It's I think like a 12 to 14 week turnaround without any sort of expedition.
No offense, but you are
so,
a stupid
you know,
asshole.
Expediting, I don't know that necessarily that can be cut in half, but it is something that I think can
Let's
be
get
turned
it.
around a little bit quicker than their typical turnaround time.
And Ms. Lundgren, you'll have your clients available, at the drop of a hat to provide this sample? All right, so go ahead, Ms. DNA.
Thank you. So, Your Honor, I think the only real conflict at this point, if the Commonwealth is holding to their motion, is their paragraph 7, which states the defendant is not permitted to conduct independent analysis or testing with either Sergeant Buchnick's or Trooper Proctor's DNA samples or profiles. Now, clearly, we won't do that with regard to the samples because we won't have them. We don't need them. But we will have the DNA profiles, Your Honor. And once we do, they, in my view, in my client's view, we should be able to use them for any case-related purpose. We have no interest in, distributing them anywhere or doing anything with them.
Hold on, Ms. Lundgren, I think you should answer this. Why don't you come on up? Is there an opposition to that?
I just need you in front of a microphone. There's one right here. Thank you.
She could take this mic if she likes.
No, because we'll be going back and forth, so you should stay there.
There is an opposition, Your Honor. I mean, I think perhaps the Commonwealth can speak to it. I think there's also a strategic decision.
Oh my
and
God.
case-related decision. Certainly, we agree with
Like,
the privacy interest that
seriously?
the troopers are providing their DNA for a specific reason and with regard to a specific item in this case. And they do want to limit that consent. However, that is more, I believe, a case-related and strategic reason that I would also defer to the Commonwealth to speak to.
All right, I'll hear from
Yeah,
Mr.
I don't
Lally.
see any
Go ahead.
reason for that.
Not now.
Right.
I'll hear from Ms. Giannetti to finish.
Right. So there is other evidence in this case where comparative testing, DNA testing, could be done. And in addition, Your Honor, I want to make it clear that our investigation has been ongoing and is ongoing to this day. We may come into possession of evidence related to this case, physical evidence, that we may want to do our own comparative testing on. And once those profiles are released, assuming that there's consent and that the Commonwealth comes into possession of a DNA profile, and the defense does as well by Mr. Lally's admission today, that should be evidence that either side can use for any proper purpose that is case related. So we should not be
Case-related.
prohibited from either
That's what a
requesting or
protective
doing our
order would do.
own, comparative analysis from those DNA profiles if it relates to the case.
What do you want to say, Mr. Lally? We're talking hypotheticals here.
We are.
Right.
So what I would say is the only other identified evidence really, or the bulk of it as far as DNA is concerned, concerns Mr. O'Keefe's clothing, which I don't understand what any relevance that would have pertaining to the troopers' DNA profiles. As it pertains to what ifs, as far as any sort of other physical evidence that counsel would come into possession to, the protective order, while somewhat ironclad, is not necessarily cement. So if there's a request for a modification based on subsequent evidence or something like that, I think that's something that the court can obviously entertain at that point. But really, the purpose of this is with reference to that one specific item.
It does make sense that if there is something later, you come before me on it.
Well,
so that's why I asked you if it's hypothetical. If you have an item that you want to test, I think the Commonwealth has every right to know what that item is.
Okay, our position would be that we should be able to
Tail
conduct
light.
our own investigation in private and reveal the results of those
For sure.
investigations.
I agree with
of
that.
that investigation, should we desire to. We have a different ethical duty than the Commonwealth. Clearly, if there's any evidence that the Commonwealth possesses that we'd like to do comparative testing on, we have no choice but to notify the Commonwealth and resolve any disputes before
There
this
you
court.
go. Yeah, but
if
you'll
we
know
come
when
into
we ask
possession
for it.
Of, anything that we believe is related to this case and should be tested, we don't believe that's any business of the Commonwealth to interject in that. We will have the
This guy is unfucking believable.
reveal the results of that testing should we desire to.
I agree with that.
Does the Commonwealth want to be heard?
Totally.
No, Your Honor.
All right.
People don't realize that like the state does the entire investigation. Like when you come in, you are relying on the evidence that they collected and all the information
My
and
co-counsel
witness
brings up a
statements
good
and
point,
interviews
which
they've
is,
done. Like
after
to think that you have to turn over all your stuff is absurd.
Yeah.
They
Well,
have
I
the
mean, yeah,
upper
they
hand.
control the investigation from the start.
And I think it
so
was weird that the
Right.
judge even implied like they had an obligation to do it. You know, like shouldn't the judge know
No,
better?
Yeah.
she was just wanting them to tell her. Like they should not have to ask permission. So put it this way: let's say that they are. First of all, I find it absurd that there's unknown profiles that clearly the Commonwealth has had no desire to figure out whose profiles those are. They're acting like they're doing it now as a
Courtesy.
gift to Karen Reed because we want
Right.
to kind of stop everyone from suggesting that there could be these two officers. But we don't want you testing anything else, though. Not his clothes and not
Well,
anything else you might have found
related to
DNA.
this case, they said related to this case. That was the limitation
Yeah.
that he asked for, and that would be appropriate, like we talked about earlier. Protective orders.
But they don't want that.
Well, I thought he just said that he didn't want them doing anything that wasn't related to this case.
They're giving their profiles for this limited purpose, which is the Commonwealth using it to do comparative testing between the unidentified profiles on the taillight and I guess
Yeah.
the
Right.
back of the car panel.
They just want to test against the DNA that's right.
Unknown. But what they're saying is we don't want them then keeping that profile and continuing to test they need to come back to the court and say, we want to test, A, B, and C,
Is
and
that
we
what
want
the
to
court
use
grants?
their profiles.
But it clearly says that already
hasn't
in the motion.
told.
It already says that in the motion. So I don't understand why the big misunderstanding is here. It clearly says that in the motion. I
Well,
read
and
it
the
yesterday.
big misunderstanding was the DNA sample, which would be the swab itself,
Versus the
as
profile.
The profile, which is basically
Right.
just a sheet of paper with a bunch of letters and stuff on there.
Got
That
it.
Yeah,
once
and the
once they
defense is
do
saying-
yeah, sorry.
Yeah, the defense is saying, give us the profile. That's fine. We don't need to have the actual sample, but we want to be able to use that profile to do testing on other things. They just had someone swab all the evidence. Like they might want to use it for comparative testing. And what the Commonwealth is saying is if they want to do that, then they should have to come back to court and argue that they should be able to do that testing.
Mm-hmm.
And she says, so do you have something or is this hypothetical? Because if you have something, tell me what it is you want to test.
Right.
And
And
he's
well, he just said, for
he's like-
example, we want to test it against the tail light. But we also want to be free to test it within the confines of this case. So what does the judge actually order? Well, she doesn't order anything yet.
She doesn't rule.
She doesn't
Nope.
rule
Right.
yet.
She doesn't rule on it. But I think she
Imagine
rules on it
DNA
later
profile.
on, doesn't she?
Imagine if it pops up on John's body.
Right.
Right. Yeah. Yeah.
And and like, well, initially when I heard them say that, I thought, oh shit. But then I realized, like, I thought, what about the wounds? Because I keep thinking about the fact that they collected that blood. Like, if you thought he got hit by a car, why did you need to collect this blood to just see? And by the way, I sent that to someone that a lot of us know from a different show that does crime scene stuff, and like he thought I was joking when I said about putting blood mixed with snow in red Solo cups. Like he honestly thought I was joking. Like, who the fuck does that?
Nobody.
They did it. I have
Fucking
pictures.
nobody.
He was like, and by the time they'd have tested it, like the snow would have melted. It would have mixed in with the blood, watered down the blood. Like he was like, surely you're not telling me the truth. And I had to like send the paperwork. But anyway, they checked that, and I feel like if I was to do that, my thought process would be I need to look, see if somebody else's blood is mixed in it. Like if somebody punched him and their knuckles bled, or there was a struggle of some sort, their blood should be in the snow here. Not to mention the whole snow blowing thing with the leaf blower, and they're blowing the snow and shit. They'd have to be blowing evidence everywhere, the taillight pieces everywhere. I just don't understand. I just don't understand.
The whole
Any
goddamn
of it.
thing. I mean, all the way back to the responding officer not knocking on the door to make sure that everybody else in the house is okay, which happens in every single case. It doesn't matter what it is. I mean, but at the very least, a dead police officer laying in the lawn, you're going to knock on the door. You're going to tell somebody there, hey, I need to check the house to make sure everybody's okay. Do you mind? You know, this didn't happen.
Well,
Yeah,
where did they
and no
get
one
the
wants
solo
to talk
cups
about
from?
length.
Leah's asking. They were at a house party.
No, they got the solo cups from a neighbor. From a
neighbor's
neighbor's house. Yeah.
Don't go
like-
to the house where
Yeah.
the body's found.
This
Right.
whole
Don't go
case
in that
is
house.
completely like when you think about it you look at it from the perspective of everything, right? In the grand scheme of everything that we know about this case, you can't help but wonder what the fuck are we even doing here? You know what I mean? Like, how are we at a trial discussing this? It's insane. It's insane. Like, this whole investigation was cagged from the get-go, and it's like they didn't even try to hide it. Like, they were so
No.
arrogant.
No.
Little devil's advocate here. Why put the blame on Karen Reed? Let's assume the boy Colin is it Colin, right? The son. Let's assume
That's
he
one
did,
theory. Yeah, that's the main theory.
but let's assume, for the sake of argument, that he unalived John, and they needed to get rid of the body. And say they throw it out front. Why then put the blame on Karen Reed? They could have easily have just said, "Well, we don't know. I don't know what happened." Why do we have to have? Because cases go unsolved all the time. And they can easily, since they're all kind of in charge of, or at least a big part of the police department, say, well, we don't know. It doesn't make sense to me that they would put the blame on Karen Reed. So that
Well, the
is-
only way to be
that's one of the issues I have with this case is why would they put the blame on her?
So, like, for example, the whole thing rests on him not having gone in the house, right? Because if he stepped foot in the house, that brings the outside investigation into the house. So
Yeah,
you
but he
can say
doesn't-
you don't know what happened all you want, but they're going to treat it like a crime scene. They'll find out or come up with a theory of what happened.
No, the police
So-
are there. The police are there. The police are the ones. It's you know, it's all the same department. It's all their buddies, right? So they don't have to place him inside the house in order for him to be unalived somewhere outside.
I see what you're saying, but I also see what Sleuthy's trying to say. That's what I'm saying also is that the thing is, we're talking about a dead police officer. People are going to want answers, plain and simple. So what's going to happen is if what they get out of blaming Karen Reed is Karen Reed is an easy patsy. Nobody really knew her. She wasn't friends with anybody there. John was friends with at least Jen McCabe. So
Julie
she's an
Albert,
easy.
Chris's wife is the one that texted him and said, "Come over here to the second bar that he went to." So I think people are
So
missing.
he's
her.
connected. Yeah, he's
Correct.
connected to the Alberts for sure. So there's that. But the reason to blame her, you have to pin it on somebody. You know what I mean? Or else they're going to start asking questions. They're going to gravitate to the investigation. It's inevitable that it's going to gravitate to that house. There's no way around
But
it.
it won't if you say he was never in here. He
The
just never
only
came
thing-
inside.
Right.
The only
right.
thing
So
is,
that's to answer your question. That's exactly why they would try to frame Karen
now
Reed
they're
on
under a federal probe at the time in 2020, or is it only? I know it's been going on for a while. Has it been like prior to 2020, prior to John's death? Has that federal probe been going on? So maybe that's why they're
not on the state troopers, but on the DA's office.
on the DA's office. Okay. So there's no pressure from the feds like, oh shit, we got to come up with a story because otherwise the feds are going to be breathing down everyone's neck. So that's not an issue. I'm just like, I'm thinking logically, right? Or trying to, right? I hope to never be in a position where I'm stumbling across a dead body and have to somehow hide it. but or cover up the crime. But if I was, why would I not just say, well, I don't know. We were at the party. He said he was coming by. Well, I don't know. You found him dead on the front street.
Because the public and this man's family are going to demand answers as to why there's a
12
dead
people in the
cop.
house saying he never showed up. I don't know. Maybe he was hit by the plow truck. Who knows?
Well, yeah,
maybe some random hobo walking down the street beat him up and took his belt.
I mean,
don't
but if
know.
you're asking that, why in the hell would Proctor file all these conflicting statements when he took these statements from these so-called witnesses?
I'm
right?
just saying, if I was in the
it's
moment,
such a
right?
sloppy investigation
It's
that
true. But in the moment, right before Proctor gets involved, all of a sudden you've got a dead body of a fellow police officer in your house, or a dying body. What are you going to do with it? Throw him outside? I don't know. We've got 12 people that all swear he never came over. He said he was going to, but never did. We don't know. Right? I mean, I feel like that would be an easier out than blaming it on, oh, Karen happened to show up. We could blame it on her.
Well, sure. I mean, I agree with you. Like, there's a lot of easier outs, but these people, my point is nothing about this investigation or this cover up seems to even make sense in the sense that they've even made an effort to try to, it comes off as totally arrogant on their part. Like, we can do whatever we want. We've been doing this for years and nobody's going to ask us anything because the DA's office has our back.
It might have been in panic mode. There's I watch a lot of interrogation videos, which are always fun to watch because, first of all, you should never, ever talk to the police. Don't talk to anyone about anything ever. That's the first.
I agree. Yeah.
But you get these people in there. There was a cop. There's been a couple where cops are being interrogated by other cops, and they're both in full uniform. And it's like, dude, you're a cop. You know this game. How do you know not to shut the fuck up? And they still talk. So it could have been panic mode, even though they're all trained police officers with years.
Right. And Olivia's making a good point too. They were all drunk,
That's
all
true,
of them.
yeah.
They were all hammered.
That was the one thing that always, like, why would you pin it on somebody when it's this complicated to pin it on them? This is
I might be able to give you.
Yeah.
I might be able to give you an alternative, maybe. So John had never been in this house. Like, supposedly he's never been inside this house in particular. So he had also been drinking. There's no concrete amount, they don't say how many drinks they saw him have on camera, but let's just say that he was sloshed and he showed up at this house. That's why he didn't drive and Karen drove instead. And shows up at the house, goes in to check, has never been in the house before. The way that the house is set up, when you walk in, you walk into a foyer, and straight ahead is a set of stairs that goes upstairs, but then there's like a door and another door, and one of the doors goes to the basement. Then there's like a closet door, and then there's like so like there's many doors. You've never been there. You're drunk. If you had to pee, let's say, and you like walked in a door that you thought was going to be a powder room, and instead it was a set of stairs, it'd be really easy to just walk in like you thought it was a powder room, and down the steps you go. Now, there is those old like cellar doors where they're like in the ground, they're like triangles and they're made of like metal, and you pull. Okay, so there's that in the back of the house. Okay. That goes from the cellar where the gym is out to the backyard. And essentially a person, if you can picture the house at all, this might be difficult to do unless I know there's people that have stared at the house, but if you were to be in the basement, in the gym, leave through those stairs to the backyard, walk up to the left, go around and go out the gate, straight ahead is where John was found. Okay. Straight ahead from the gate. And so what if an accident happened or there was a fight inside the house? And what if when John got outside, he wasn't already unconscious? What if he was told to leave, or he got kicked out of the house?
I don't think he was necessarily dead when he left the house. I think he was probably still
he
alive.
wasn't. Right. He wasn't. He
But if he hit his head, or something
ahead,
happened, you know,
sorry.
where he hit his head or whatever, he could have possibly got out there before passing out.
True.
Now, so let's pretend then that you go to bed. These people leave. The only thing that I can't justify in my mind is the 227, how long to die in cold. And technically, I can explain that in the sense that they're leaving. Jennifer McCabe is in the passenger seat. She sees him in the yard, knows that he's drunk, knows that he got kicked out, doesn't want to go against Brian and go get him out of the yard. So just leaves him there, but she's concerned, right? This is hypothetical. So she goes home and she's still worried. She can't sleep. She's
I'm
Googling,
not
like,
sure the
how long will it
wounds,
take? Is it
though,
going to be okay?
the injuries are consistent with falling like that, you know?
Well, his
I
head
thought
would
you were
be,
going to
but
go
let's-
with, like, he stumbled into the wrong house and the neighbor beat the shit out of him.
No,
that has a
no,
dog.
No, but listen, if Brian Albert let that dog out back, there was a comment about what was said inside the grand jury minutes where he said the dog really wasn't like a people dog. It didn't really like people. That means the dog bites. Okay.
Sure.
So he put the dog outside in the backyard. It's fenced in. So let's just say, for shits and giggles, if John did leave out of that cellar and didn't know there was a dog out there and the dog didn't expect someone to come out of the cellar, it could be possible that he drugged, you know, the dog all the way to the fence before he could get out the gate, you know?
Yeah.
And
Yeah,
so
I mean,
I just think,
but that scenario or any other scenario doesn't place the blame on Karen and doesn't still alleviate the ability for all 12 or however many people were in there to say, oh, he was never in here. He said he was coming over and we never saw him.
I don't
You know,
think
I don't know.
that
It just
came
seems
from
like
them.
how you, okay.
No, I don't
but
think it came from them.
how do you impeach? How do you impeach? Oh,
right.
Impeach that.
Well, see, people forget about Michael Lank. Okay, he was one of the only people that went in. Like, Michael Proctor didn't go inside the house. Lank did. Sergeant Lank went in the house, and you can find the court document. I don't know that I have it in the spreadsheet, but you can find the court document. He previously kind of stepped in for Chris Albert. Chris Albert will pick a fight, and then people in power jump in and help him. And he like beat the piss out of somebody, arrested them because they like were getting into an argument with Chris Albert. So I'm just saying, is it possible that when Lank went into the house, someone or all of them was like, holy shit, you know, this is what happened or whatever. And he said, John never came in here. You never saw him once you left there. You didn't even know, Brian, you didn't even know that he was coming here.
There's
I think just to clear things up, I think you
So
mean
that no one
Colin,
goes
not
in.
Chris.
Yeah, Colin.
You mean Colin, not Chris, right, Sleuthy?
No, Chris.
You mean
Chris?
Okay.
Yeah, his
Well,
father.
I mean, we can speculate all we want. There's a million different scenarios here that could have resulted in him being dead. My point is that I'm almost certain I would, if I was the prosecutor, I would, in my opening statement, say something of the sorts. They're going to try to convince you that this is one giant frame and that Karen had nothing to do with this and that all of these witnesses that you're going to hear are corrupt. But let me ask you this.
Gaslight the defense from the get-go. Right.
Why would they create this weird, complex scheme when all they had to say is, oh, he never showed up? Why would they go through this? And I guarantee,
because then they would look at the kids. They would look at the kids who was pulling away at that time. They would look at Jennifer and Matt who pulled away drunk.
It's a way to just get out in front of the defense's argument, and the jury's going to be sitting there the whole time. Every time the defense does a cross, and anytime anything happens, they're going to be thinking about this prosecutor. You're like,
no, I see exactly the point you're trying to make, Dave, because I mean, but the answer to that question, which is why wouldn't they just do that? It's the same answer as to why the hell Michael Morrissey would make these blatant public statements that could easily be disproven. You know, and why would the DA just be as sloppy as they have been this entire time? I mean,
There's no sense behind anything that they've been doing this entire time. There's
That's the thing. Like that's where my mind always goes, because as an attorney, I'm always thinking, I'm trying to think of what the other side's going to do, what the other side's going to say, how I would frame the issue if I was representing the other side. And that's the one thing that I feel like the defense is most vulnerable with. Why would you come up with this weird complex scenario of a 3-point turn and driving at a certain speed and hitting him and all this stuff? And you know, we don't have
misdirection
custody for
misdirection.
Why would we come up with all this stuff when we could just simply come up with another excuse like he never showed up? Don't know.
Well, they do use that though. They use that also. And a lot of the other things that you're mentioning, like, show up after they're being probed about it. Like, what you're saying doesn't make any sense. Oh, well, we got the vehicle information back, and it says that she backed up, 24 miles per hour for 60 yards, and she hit him, and there was an impact. And so, but in the next breath, they're like, but we haven't gotten the data. We're not capable of reading the data yet. We have the raw data, but we don't have any way to read it to see what it says. Well, then where are you getting this other information? So I think that.
And the problem for any prosecutor is they need to lock themselves into the small little box and say that this is the truth. This is what I'm telling you beyond a reasonable doubt. And anything outside of that or starts poking holes in that box is a problem for them. So they must be very specific and very confined to the small little box that they've developed for themselves. And so there are cases out there where, like the Zachariah Anderson case, where the prosecutor in his closing arguments, I says maybe like 24 times. But outside of that, generally they need to lock themselves into this is the truth. And so both sides are playing with something. Well, this is the truth. Why would we have to, or if it's not the truth, why would we have to concoct this scheme? I'm just trying to think of all the different avenues in this case. It's a very weird case. He obviously is dead. I don't think Karen had anything to do with it, but the defense it still is an uphill battle. I don't think it's as easy as you guys are thinking it should be.
Right.
This is going to be a very challenging defense case.
I think their behavior throughout this whole thing also is another reason why I don't see wanting to, at least the defense, wanting to change to a new venue, because I feel like the people who are local that are in agreement with it, like, you have to, and that's just like the stuff we know about. I'm sure there are other stories we haven't heard about people that think or have experienced different things from either the Massachusetts State Police or the Canton Police Department. Yeah. So keeping it local with people that have experience with these particular officers might be better for the defense. But they seem to they don't seem to expect really to go to trial.
Hang on, I'll be right back.
Yeah. The Julie C., this is one of the first observations I made even looking into this case initially, was I found that weird, having covered other trials. You never see the defense actually be on the offense, which is very telling. Oh shit, I'm all alone here. It's very weird that the defense seems to be on the offense. That's something that I've never seen before, because a very simple fact about these cases is the burden of proof is on the prosecution, and the only thing that the defense actually has to do, what their job is to simply create doubt in one juror. There's so much to do that with. So why are they going the extra mile to implicate police officers and family members and friends of these police officers? So it just kind of seems, to me, that's very telling. So, and I'm just waiting for, I don't know what happened to Sleuthy. I didn't boot her off, and I'm waiting for Dave to come back. Yeah, justice for John for sure.
You're good.
Yeah. Right on. Do what you got to do.
Oh, did we lose what, Sleuthy or
I don't know what happened to her.
Oh, okay.
But yeah, what I was saying, I don't know if you heard me, but I find it very telling, and I found this weird initially when I first started looking into this case, is the defense seems to be on the offense here, which is not something that I normally see. To me, is very telling, because the defense's job is basically just to create doubt in the jury, not to prove and implicate other people. And when there's already so much to create doubt already, why go the extra mile unless there's, I think just good lawyering or what?
Well, it is good lawyering, and most defenses go on the offense to some extent. I think what you're seeing here mostly is because most of it's been discovery motions, right? So they're not getting the information that they need. They're not getting a cooperating state. And so they're going on the offense against the state to get the information, the evidence, and things like that. If the state was cooperating and turning over stuff that they were asking for, we wouldn't be in court. And you would be like sitting there like, well, what's going on with Karen Reed? How come we haven't heard anything? And why isn't the defense doing anything when they're really working in the background? So I think the reason why it looks like that is just the state is putting up a fight with all this evidence. So, but most of the time we are doing it. Like I have cases right now, criminal cases, where I'm constantly asking the prosecutor for documents and information, but I'm literally sending emails, and then they send an email back with the information. So there's no motion. It's not looking like we're like super offensive. There should be a couple of motions. You should see some motions to like a motion in limiting to suppress evidence or protective orders and things like that. There should be some random motions like that, but you typically don't see it because usually the state plays with the rules and, plays along with the rules and does what they're supposed to do and turn this stuff over. They're not doing that. And that's why it looks like they're so offensive.
Okay. Right.
So it's the state that's creating it. And like I say, too, with all cases, you're always responding to the other side, so you do something, and you got to see how they respond. You ask for something. If they don't turn it over, you got to file a motion, and then you look super aggressive and going on the offense. And it's the state creating this scenario because they're not turning over this stuff. Yeah.
Right. So that's what's making the state look bad, is because, the defense is going, well, just why aren't you sharing the evidence with us when it's your job to do that? Why, what's the problem? And it makes them look almost suspicious. It would make sense to build off of that as a,
And if you're the state and you're so worried about Turtle Boy and Tom CPU and other people talking about this case and, oh my God, they're influencing the jury. Well, keep it out of the freaking courtroom. Cooperate. Right. Send the stuff via email when they ask for it, and it won't be out there everywhere. You're your own worst enemy at this point, state.
Totally. And it just makes it makes you just wonder what in the hell is going on with Michael Morrissey's office, which in turn just makes the fact that they're being investigated federally make perfect sense.
Yeah.
So yeah, it's crazy to me. This is totally crazy.
Yeah, this is a weird case. It's just weird all around. It's weird the way they're handling it. It's weird the way they're not turning over information. Clients all the time tell me, well, I don't want to turn over this or that. And it's like, well, they're going to get it anyways. And the more we fight, the more suspicious it's going to look. So just turn the damn thing over, so it's, not necessarily in a criminal context, because I don't work for the state. I'm always working for the defense. And then we don't turn anything over unless we're ordered to. But on the civil end, if you're like the plaintiff, so in the state's position here, and it's like, listen, this is your case. You brought the case, and now you're going to put up a fight about turning over documents or this or that. It just makes you look like you're hiding something, and it weakens your case. So why are we playing this game? Just turn it over.
Yeah, it's so crazy. Like, just the way they've been handling, like, all the way from the investigation, as Bob Brown's saying. I keep making this point every time I do a stream on this. Just the fact that the investigation alone should exonerate her in court, whether she's guilty or not. I mean,
if all of this misconduct took place during the investigation, that should exonerate her because her rights were violated. That violates her right to a fair trial to begin with, even back in the investigation part of this.
Right. Yeah, there's just a lot of well, you can even see it in that attorney's argument early on when they were arguing regarding the communications between whoever and that person. I don't think it was a sincere argument. He can't justify it in his mind because he knows he's wrong by putting up a fight about this. He knows it's relevant. He knows it could be used to establish a bias. Therefore, it's relevant to impeach a witness. That's the thing, right? So evidence is relevant if it tends to prove or disprove a fact that's material to the case. But that's only one part of it. Evidence is also relevant if it could be used to impeach the credibility of a witness. And that's what they're going for. And so he knows his argument is bullshit.
Right.
So anyways, I don't know what else to say about that. It's just stupid.
Yeah. I don't know what happened to Sleuthy, but I try to wrap these things up by 3 hours. So I'm going to go ahead and ahead and do that now. But I really want to thank you for coming on such short notice. Like literally an
no problem.
hour
I cut the
before
other stream short. We're fine. No, it wasn't even my stream. I went on with Nick Staroff. You saw him in the chat. You pulled up his.
Okay.
I was on with him, and he was having some issues. So then I started streaming the trial that we were watching, and I'm like, okay, so I can't stream this the whole time because I got to go jump over to this other channel at 7. He was like, all right, so we cut it short. But
oh
he was
man,
for
yeah,
a
you
long
didn't have to do that. I mean, I could have just had this going
it was
until
fine.
you were ready.
He was good. He's
But,
in Sweden, so it was like 1 a.m. by the time we cut it short over there. So he's fine.
Yeah, I literally just had the idea. I was like, you know what? Let me reach out to Making Law Simple to see if just take a stab at it. And it was literally an hour before I had this scheduled. And
yeah,
and
no, I was already
sure.
hanging out in the treehouse, so no worries.
Yeah, right on. I'm really glad you did, and I really appreciate it. Thank you, guys. Make sure to subscribe to Making Law Simple if you're not already. I know a lot of you guys already are. We got the same mic. Look at that.
Oh
yeah. So yeah, I appreciate you guys being here. Thank you so much, Dave, for being here. And again, guys, make sure to subscribe to Making Law Simple. I hope to do something again with you in the future.
Yeah, absolutely. I know we were talking about doing something, and then you're like, "Hey, can you come on now?" Like,
we were, yeah. we had something in the works, but nothing solid. And then I was just like,
yeah.
So
I'm always streaming. Just shoot me a DM, and I'm sure I'll jump on.
Right on, man. I appreciate that. That's awesome.
No
Thanks again for coming, man.
No, thanks for having me.
Right on. All right. Have a good night, man.
You too.
Again, I don't know what happened to Sleuthy, but Sleuthy, if you're listening, I appreciate you joining. It means a lot. And hopefully in the future we'll have Olivia on. I wanted to have her on, but she's feeling under the weather, so I really hope that she feels better. Yeah, more stuff to come, guys. We're gonna talk about Sandra Birchmore coming up soon, because I wonder why the hell more people are not talking about that. That needs to get blasted, especially considering the similarities in this case. So anyways, guys, I appreciate all your support. You guys are amazing. And way to go, guys. Those of you guys that were out there in front of the courthouse, that was amazing seeing that. Tom, CPU, thank you for catching that footage. And all of you guys just for being so great. I'm absolutely loving this community, and it really means a lot to me that you guys have embraced me in it. So thank you guys so much. So I'm going to call it a night. I love you guys, and we will do this again very soon, my friends.